Cienījamie konferences
Dear participants, please take your seats.
participants, please take your seats. Lūdzu jūs visus piecelties.
Please rise for the national anthem of the Republic of Latvia.
Anthem of the Republic of Latvia.
Cienījamā
Honourable President of the European Court of Human Rights, esteemed Justice Supreme of the Supreme Court, colleagues, judges, participants of the conference, welcome to Latvian capital Riga and the international conference organised by the Constitutional and Supreme Courts, the role of the Judiciary in the execution of judgments of the European Court of Human Rights. This conference promotes the strengthening of values that for 7 decades have been at the core of the European Human Rights Convention and values that are at the heart of its enforcement. Council of Europe is the project that promotes peace and humanity. It brings together countries that respect freedom, prosperity and security, countries that would like to avoid wars and totalitarian regimes that we have experienced in the past. These values are based in 3 interlinked and complementary principles: democracy, rule of law and human rights. Any of these pillars is important for the sustainability of the other pillars. In scope of its presidency of the Committee of Ministers of the Council of Europe, Latvia will focus on rule of law as the bounding value for Europe, and we are going to strengthen this value. As regards to rule of law, I would like to underline that the institutional framework of the Council of Europe is based on separation of powers, and that is why country governed by the rule of law and independent judiciary branch are characteristic and intrinsic to the European identity, and therefore efficient execution of judgments as part of the right to fair trial is an important part of European identity. It is our common responsibility, dear colleagues, to make sure these judgments are executed properly, because without the proper execution of these justices, right to fair trial would only be a shell and meaningless right. And non-execution of judgments may also harm democratic systems and lead to authoritarian, totalitarian, and internationally aggressive regimes. The examples of weakening rule of law to deconstruct democracy are right in front of us. In Russia, it all started with the marginalization of the independence of national courts and the non-execution or ignorance of the European Court of Human Rights judgments. Therefore, we should always remember that non-democratic yet seemingly countries that are governed by the law are a utopian dream, and the so-called good dictatorships are virtually non-existent. Dear colleagues, by guaranteeing the right to fair trial, we will find ourselves in a situation where execution of judgments will require out-of-box thinking and unorthodox solutions. It's quite a great challenge to make sure we coordinate our actions for the execution of judgments in high-profile cases, requiring us to come up with politically and legally very complex solutions and an integrated or holistic approach. This means that in execution of judgments, we need a dialogue that is based on respect and loyalty, and we need this dialogue not only between the ECHR, Committee of Ministers, but also within the institutions that pertain to the national judiciary. And the role of national courts is absolutely vital. In this context, in our first plenary, we will talk in particular about the importance of such dialogue, whereas the main challenge for national courts trying to find the best solution in a particular case is the ability to detect a wider context, whereas the legislator has adjusted legal framework to the case law of the European Court of Human Rights, especially in cases against other countries, and how these findings or conclusions apply to our particular national systems. In other words, a judge in a national court must actively follow the case law based on the articles of the convention, and also very carefully manage the risks of overstepping his competence and stepping into the competence of the executive or legislative branch. Dear colleagues, I will have an extensive discussion on this. In conclusion, dear colleagues, in order to strengthen the rule of law across Europe, Latvian supreme judiciary institutions have organized the conference to discuss the various ways of monitoring the execution of the judgments of national court and the role of national courts in executing the judgments of European Court of Human Rights, that every European, everyone that belongs to 600 million Europeans that are protected by the convention will benefit from this. So would like to wish you constructive discussion on how to strengthen the rule of law in the European cultural space. Thank you. Dear guests, good morning. Colleagues, dear participants, friends, good morning. We are meeting literally 5 months after the Reykjavik summit that specifically highlighted the role of the European Convention of Human Rights in ensuring the fundamental human rights. The convention is the very document that we have to follow on an everyday basis, and we have to implement and follow it not only at the level of the European Court of Human Rights, but also at the level of the judges of the national courts. And this convention is absolutely essential for the European Court of Human Rights and national courts alike. And in their case law, the ECHR constantly reminds that it's not a fourth instance court. It does not substitute or work instead of the national courts. On the contrary, it evaluates the compliance of the national court judgments to the principles of the European Convention of Human Rights, and it complements what the national courts do. We shouldn't be afraid of the ECHR, as sometimes our colleagues claim, because we're talking here about synergies, about single system with various branches that work together, that interact to benefit everyone, especially the citizen of the European Union. Well, when it comes to law, there's a certain formalism acceptable because legal science is very formalistic in essence. However, excessive formalism in application of the laws, when we lose the sort of the meaning of the judgment, would be detrimental to the rule of law and fairness and justice. And there has been a huge debate also in Latvia regarding the execution of judgments of the European Court of Human Rights. I'm talking about cases when formally we do what the judgment requires, but actually fail to solve or address the causes of the case or a challenge or a dispute. And there are different reasons globally: political, constitutional, psychological, sometimes even, mental problems could be blamed, and that's a joke, of course. But what I'm saying here is we have to not only formally execute those judgments, but execute those judgments based on their merits. And when I'm talking about merits, it's not about solving the dispute or dispute resolution according to the law. I'm talking about judgments that contribute to the development of legal science and legal thought. This is what we should focus on when executing judgments. And of course, situation varies from country to country in the European Union, contrary to our Western European partners. In Latvia and in Eastern Europe, unfortunately, we're living next to an aggressive neighbor who has started or launched this aggression, and we are living with a war in our backyard or neighborhood. So we can't forget those threats that this creates. We are constantly reminded of these threats by security services as well, because hybrid attacks have increased multiple times since the invasion of Ukraine, and dare I say, Eastern Europeans, those especially who are bordering with Russia, are exposed to these threats to a greater extent on a daily basis compared to the rest of Europe. On a daily basis, we actually encounter these risks and these threats. This, of course, does not diminish the standard of the human rights that we are following. However, it requires us to approach courts in a different manner when it comes to risk management. It is a true art to find a balance between the standards of human rights and self-defensive or self-defending democracy, or combative democracy, as it is called somewhere else. The paradox of democracy is that it is a messenger of its own, and it allows the opposition to act against the democracy, but various instruments of democracy must be applied very carefully to avoid the dismantling or the collapse of democracy. And in this respect, a huge, if not decisive, role is played by the courts in maintaining the integrity of the democracy. This morning, giving an interview to the Latvian radio, I was asked, what do we do if politicians do not comply with the European Court of Human Rights or the Constitutional Court judgments? So if country fails to execute the judgments of the European Court of Human Rights, as is the case with the also with the Constitutional Court, then the responsibility is on the country, not particular politicians who have taken these decisions. You cannot jail a politician for not following the judgment of the Constitutional Court or the ECHR, and that is unfortunately the fact that we cannot change. But Latvia can be an example, a role model, in a sense that non-execution of the judgments of the Constitutional Court is then contested in courts, so there's no political debate. Any judgments regarding the application or the execution or the following of the Constitutional Court judgments is then contested in a regular court. It is probably not as swift as other procedures, but it works. And today we'll probably come with the new ideas or alternative ideas on how to make this execution better. And at the moment, we are, of course, very much concerned about the rights of the displaced minors because of the war, their property rights, inheritance rights, and their status and benefits, which are very important in current geopolitical environment, again, as we live next door to the war, to an aggressive neighbor. And these issues have also become very prominent in the European Court of Human Rights, and the recent statement of Madam O'Leary on the 70th anniversary of the ECHR. But without further ado, let's get to work. Thank you for finding time to attend this conference. Nice to see so many renowned experts in the same room, and good luck to everyone.
Labrīt, cienījumā.
Good morning, Honourable Madam O'Leary, Minister Lavinch, Minister Strupish, Ministers, friends of Judiciary. On behalf of Madam Minister Ines Libinja-Egner, I would like to convey her apologies for being absent from this conference. She's wishing you a very constructive conference, and hopefully this conference will contribute to strengthening of rule of law and democracy. Minister is thankful to you for finding the time to attend the conference and promote the common cause of the European project, which is the strengthening of our common values. The presidency priorities of Latvia include strengthening of democracy and human rights. We hosted the Ministers of Justice meeting in Riga 10 days ago. We agreed on Riga principles during this meeting, and we also agreed on creation of the register for damages for Ukrainian victims of the Russian war. Together, we must make sure that justice prevails and impunity is eradicated at international and national level. We are starkly aware that the international rules-based protection of human dignity are under threat right now, both directly and indirectly, through military and hybrid threats. Today's Europe is not the Europe that we used to see several years ago, because today we have to stand on guard of the Council of Europe values like never before. Europe is currently torn by war that is being waged by a permanent member of UN Security Council against the sovereign country of Ukraine. Russia is currently brutally ignoring the Council of Europe values and killing Europeans, and the consequences of this war or aggression echoes around the world in various ways. We are united in our defense. We stand behind Ukraine, its international rights and status, and we are faced by hybrid threats because of that. Hybrid threats emanating from the aggressor and its supporters. At the same time, we hear about cases when windows are shattered of the Ukrainian cars with Ukrainian license plates, and we have shockingly high, according to opinion polls, support in Latvia to the Russian war, despite the atrocities that we read about in the news. So we are constantly here and in Europe fighting for the integrity of our democracies, strengthen our resilience, and reduce the influence or soft power of aggressor country, and international rules provide for the strengthening of the security, justice, cooperation, predictability, and common values, whereas hybrid attacks try to undermine these values, and hybrid war and hybrid threats have become the main challenge to the national security and national governments and courts, because courts eventually decide on what should be the sanctions to those who draw their Z's on the Ukrainian refugee cars, and courts are the ones that ensure that the human rights are being respected, democracy is respected, our statehood is intact, and so society is protected through courts and through preventive punishments. And the judiciary branch is to a large extent influenced by what is acceptable and what is not acceptable to the society. A punishment is a preventive measure to indicate the damage that potentially further offences could cause to our society and its assets. And drawing disease something different than it was 5 years ago. The context has changed. The damage and consequences are different, the same as glorifying Russian flag and using various military symbols of Russia. Through various tools, through rule of law, we can solidify the trust to the government, its institutions, and international organizations. We must act together both on international and national level. We must protect the values of the Council of Europe, and not only with some abstract instruments, but also in a very specific context in which these values are undermined. From our ability to protect the victims, the trust towards government as a whole will depend, and the more people trust the government, the better they will be able to stand the hybrid war. A country governed by the rule of law is a strong country and resilient towards hybrid threats. Justices, ladies and gentlemen, the main purpose of the Council of Europe is to defend democracy, rule of law, and human rights that are inscribed in the Convention and its protocols. And the ECHR, national courts, legislature, and executive branches are the ones that implement these values in everyday life of everyone. It is very much dependent on how we succeed in executing those judgments and how we apply those judgments in practice, as Mr. Strupish mentioned. That's why dialogue between courts and other branches of the government is extremely important, because it ensures that we understand similarly what it means to ensure the rule of law. Looking at today's agenda, I see that this dialogue will be ripe also in future. Thank you very much, and wish you a very constructive conference. Thank you.
Tā, cienījamie kolēģi,
Dear colleagues, as it was just said, it's time to start working on our agenda. So I'm now inviting the speakers of our first plenary session to take the seats here in the front.
Session and Madam President, Madam Ineta, Madam Basak Chali, and Marulina Cirli, and Anita Kovalevska, please. Jā. Tā, mikrofons darbojas, viss kārtībā.
So the mic is on. Dear colleagues, already in those introductory speeches, we saw that several issues were highlighted, problems that we should talk about in this conference. We should discuss importance of dialogue between different institutions that could promote reinforcing the rule of law. We should also speak about enforcement of judgments by the national courts and the European Court of Human Rights, whether it is done formally or on their merits. We should also speak about the national judge who has to review so many different cases, how the national judge should find bearings in the case law of the European Court of Human Rights, which is very extensive. Because as we see in the recent case law, we see very clear tenet appearing. Namely, in those cases against the findings included in judgments against other countries are not applicable only against this state, only in reviewing cases from this state. It's quite clear, the message is quite clear. And this comes from several cases reviewed in 2023. For example, even if a case is against Italy where an infringement has been identified, and the specific legal issue has quite universal nature, this means that also in other countries the judges should examine this matter and decide whether the findings of the European Court of Human Rights are relevant in the specific case. Otherwise, again, there is a risk that an infringement could be found later. I believe these are the issues, the problems that should be examined. And during the first plenary session, we will be listening to excellent speakers. And I do appreciate that the President of the European Court of Human Rights is with us in this conference. And her keynote speech is importance of execution of judgments by the European Court of Human Rights as a safeguard of the European rule of law. And so it's very important, Madam O'Leary, to hear how we see the expression of this significance, the manifestations of the significance.
President Lavins, President Strupus, Deputy Minister, judges, ladies and gentlemen. It gives me real pleasure this morning to represent the European Court of Human Rights, and let me start by thanking the Latvian presidency for including the important and at times complex question of execution amongst the priorities of your presidency. Thank you also to the Latvian authorities for organising such a warm and beautiful musical welcome this morning. I don't need to remind this audience that the European Convention on Human Rights, which entered into force over 70 years ago, represents the most advanced supranational system for the protection of human rights, giving individuals the right to take a case before an international court. High contracting parties, for their part, assume the obligation to effectively protect the rights and freedoms enshrined in the Convention, accepting international monitoring by the court in Strasbourg while respecting the authority and autonomy of that court. Both this obligation and the acceptance of the court's jurisdiction flow inexorably from Articles 1, 19, 32, 34, and 46 of the Convention. Why do I say this to you this morning in my opening words? Because this fact is a point ignored of late in certain quarters when it comes both to the judgments of the court and to interim measures. As the court recalled in its memorandum for the Reykjavik summit, over 1 million applications have been processed in over 60 years, resulting in over 26,000 judgments. Those judgments and decisions have rendered major services to the development and consolidation of the standards necessary to guarantee that our democracies are and remain underpinned by the rule of law. The latter is one of the 3 pillars on which the Council of Europe was founded and which it was designed to safeguard, as transpires from the preamble of the statute and from the requirements of membership enshrined in Article 3. Respect for the rule of law is a precondition for the accession of states to the organisation, and let's not forget, repeated failure by a member state to uphold the rule of law and convention values triggers suspension of rights, or as we have seen, cessation of membership. According to the father of Athenian democracy, Solon, society is well governed when its people obey the magistrates and when the magistrates obey the law. When court judgments and decisions are not executed, it's the integrity and functioning of the whole system, whether national or European, which is undermined. And let us be clear, the challenges facing the convention system today are particularly concerning, with the values held dear by European pluralist democracies squeezed between the hammer of external threats and the anvil of internal democratic erosion. In a state governed by the rule of law, final and binding judgments of national courts must be respected without exception and in a timely manner. And the same requirement applies to the judgments issued by the Strasbourg Court in relation to respondent states. Failure by high contracting parties to execute the court's judgments undermines the authority and credibility of the convention system to which states have sovereignly subscribed. The implementation of the court's judgment is complex and multifaceted. The court finds a wide range of different violations in relation to different convention articles. One size clearly doesn't fit all. In addition, as regards the contracting parties, there's no single model of implementation, but instead a wide variance depending on how the convention is incorporated into the national legal order and whether one or a plurality of national actors needs to be implicated. In the time available to me this morning, I'd like to set out some of the recurring obstacles we see to loyal and timely execution, further illustrate how deficient execution undermines the convention system from both a legal and practical perspective, briefly explore how it also impacts on broader European rule of law issues, and finally look at how to respond to deficient execution both at Strasbourg and national level. According to the 2022 annual report of the Committee of Ministers, the latter closed the supervision of 880 cases last year, including 200 leading cases. Although failure to execute remains an intractable problem, which is why we're here gathered in Riga today, it's important to remember that the great majority of judgments in relation to the majority of states are executed satisfactorily. Latvia is a good case in point, with 5 cases closed in 2022, and generally around 94% of cases transmitted to the Committee of Ministers having been closed in the past. Although 2022 saw an increase in the total number of judgments currently pending execution, I'm glad to say that this is a reflection of the increased judicial output of the court in that period. The total number of cases pending remains one of the lowest since 2007. 4 different types of obstacles to execution can roughly be identified: deliberate political opposition, practical and/or financial difficulties, the absence of an effective execution mechanism at domestic level, and resistance derived from, amongst others, reliance on national constitutional identities. Cases of deliberate political opposition are the most sensitive, but to the extent that they turn on a political decision and don't necessarily require heavy structural reforms or the commitment of financial resources, they should be the easiest to resolve. As per the statute and the case law of the court, the Convention translates common European values, as the presidents have underlined, such as the rule of law, in a community of 46 states, whereby membership is contingent on respect for and adherence to those values. Behind the first two cases which saw the Committee of Ministers trigger the infringement action provided by Article 46, paragraph 4, Ilgar Mammadov against Azerbaijan and Kavala against Turkey, lay political opposition to the faithful execution of the court's principal judgments. Both cases concerned the arbitrary detention of the applicants and a clear instruction to order the immediate release either in the body of the Strasbourg judgment or in its operative part. As regards Kavala, as many of you know, more than 45 months have passed since the court's principal judgment, and a further 14 months since the judgment finding an infringement. 2 days ago, the Committee of Ministers discussed under Article 46, paragraph 5, what further measures are required given that Mr. Kavala has not been released, and I understand that it will issue an update or a decision tomorrow. Deficiencies in the timely execution of court judgments may also be due to practical or financial difficulties. This is typically the case where the general measures necessary to comply with the state's obligations under the Convention require significant financial commitment. In 2021, for instance, the Committee of Ministers ended its supervision of execution of the Oyal against Turkey group of cases, in which violations had been found, amongst others, of the right to life and the prohibition of inhuman treatment on account of medical negligence in state-run hospitals between 1996 and 2008. Following delivery of the first court judgment in this case in 2010, the Turkish authorities implemented significant reforms to increase the quality and capacity of healthcare services. Other examples of concerted efforts to execute pilot and quasi-pilot judgments on conditions of detention via state investment in the prison sector can be seen, for instance, in Croatia, where following the court's judgment in Senbauer against Croatia in 2006, several measures were adopted, including the renovation of a number of prison facilities, and the Committee of Ministers closed this case in 2020. Torrigiani against Italy or Vasilescu against Belgium are further examples where execution has been closed or not, depending on whether the structural problems identified in the court's judgments persist. Another barrier to timely or correct execution of court judgments may be the absence of an effective structural execution mechanism at domestic level. This is mostly due to a lack of administrative coordination between relevant authorities and doesn't necessarily derive from conscious government actions or omissions. With the correct political will, this type of difficulty can be remedied relatively easily. Slovenia is a good case in point. In 2015, it set up an interministerial working group on the execution of the court's judgments, followed the next year by the creation of a project unit within the Ministry of Justice tasked with proposing and coordinating execution measures across all the relevant national authorities. The fact that Slovenia now has one of the best records in terms of execution, with 98% of closed cases before the Committee of Ministers, is surely not unrelated. Probably the most sensitive issue when it comes to execution is resistance that derives from reliance on national constitutional identity. And this aspect will be discussed later by Judge Anita Zimmele this morning and in a panel later today. Let me just say a few words here to set out the context by looking at the case of Germany. Germany has a very good record in terms of applications before the court, with 0.6 applications per 10,000 inhabitants against a member state average of 0.54. In terms of execution, it currently has only 5% of the total number of cases transmitted for supervision still pending before the Committee of Ministers. German superior courts have engaged in constant and fruitful dialogue with the Strasbourg Court, and this dialogue has managed to overcome some traditional resistance from, for example, the Federal Constitutional Court in areas deeply rooted in German legal tradition. However, even with a state like Germany, with a good convention record, we see how what I could describe as ambivalent domestic court statements can be picked up and used in other contexts to resist abiding by Article 46 obligations. In a case called Gorgulu against Germany, the court found a violation of Article 8 in proceedings relating to the custody and access to the applicant's child, who had been born out of wedlock. Following that judgment, the Federal Constitutional Court granted visiting rights to the applicant, thereby aligning itself with the Strasbourg Court judgment. However, in its 2004 judgment, the Federal Constitutional Court emphasized in an obiter dictum that it retained the last word on national constitutional sovereignty. I quote, "The basic law aims to integrate Germany into the legal community of peaceful and free states, but does not waive the sovereignty contained in the last instance in the German constitution." Let me stress that there is a non-hierarchical dialogue between the Strasbourg Court and national constitutional courts is not in itself problematic. Indeed, a system based on shared responsibility depends on and accommodates such dialogue. However, it's noteworthy that the Federal Constitutional Court's decision in Gorgulu was referred to by the Russian Constitutional Court in its 2015 decision when it ruled that the Russian Constitution had supremacy over the European Convention on Human Rights. And it was picked up again by the Constitutional Court of Poland in its judgment of the 10th of March 2022, where that court found certain aspects of the Strasbourg Court's case law on Article 6 and judicial independence, stemming from the judgments in cases like Broda and Boara or Reykjavik against Poland, to be incompatible with the Polish constitution. A system based on shared responsibility depends not just on trust that the Strasbourg Court remains sensitive to national, cultural, and constitutional heritage, as it has always proven to be, and in this respect I point to a recent judgment of the 14th of September 2023 in a Latvian case, Valjulina. But the system of shared responsibility also depends on a commitment to stand together in defense of common European values, not least respect for the rule of law, rather than erecting national constitutions as obstacles to compliance with states' obligations under international law. This is why it's only in exceptional circumstances that the Strasbourg Court can accept constitutional heritage or identity and accommodate it within the margin of appreciation accorded to states as a legitimate ground for a finding of no violation in situations which would otherwise be problematic under the Convention. As I tried to explain, together with my colleagues, Judges Grosseff and Liemans, in our joint dissenting opinion in the case of Savickas and others against Latvia, the very concept of constitutional identity must be subject to a narrow interpretation associated with the fundamental structures, political and constitutional, of the state. Otherwise, we may find ourselves on a very slippery slope in a convention system serving 46 quite heterogeneous states, each with their own history and each with their own imprint of history on that country's culture and society. As I said before, the binding legal force of the court's judgments and decisions flows inexorably from Articles 1, 19, 32, 34, and 46 of the Convention. Failure to execute the court's judgments not only contradicts the basic Convention construct, but fundamentally weakens the right of individual application embedded in Article 34. If we draw a parallel with the domestic dimension, as the court has repeatedly explained, Article 6, paragraph 1 of the Convention protects the interpretation of final binding judicial decisions. In Scordino and against Italy, for example, the Grand Chamber concluded that the right to see such decisions executed is an integral part of the right to a court. Since Golder against the United Kingdom in 1975, and as illustrated more recently in Grezda against Poland, the court has established a direct link between the right of access to a tribunal, which, as we've just seen, includes the right to execution of final binding decisions, and the principles of the rule of law and the avoidance of arbitrariness, which underpin much of the Convention. Failure to execute final and binding judicial decisions undermines the credibility and authority of the judicial system, and in the end, of the state or system which a given court is designed to serve. What would be the point of putting in place a system where people can hold public authorities to account before the courts if the decisions of those courts remain ineffective? The same applies, mutatis mutandis, when it comes to the Convention, as demonstrated by the terms of the articles of the Convention that I've just referred to. In its infringement judgment in Kavala against Turkey, the court emphasized that the whole structure of the Convention rests on the general assumption that public authorities in member states act in good faith. That structure includes the supervision procedure, such that the execution of judgments should also involve good faith and take place in a manner compatible with the conclusions and spirit of the court's judgments. From a practical perspective, deficient execution of the court's judgments has been consistently evidenced over 2 decades by the evolution of our caseload, a point made throughout the Interlaken reform process by successive court presidents. Around 80% of our current docket is composed of applications concerning questions in relation to which the case law of the court is well established, if not very well established, or the cases are repetitive. Repetitive cases are cases in which contracting parties have failed to take effective steps to remedy the underlying systemic or structural problems previously and often repeatedly identified by the court. As a consequence, a significant part of the court's already scarce resources is diverted to dealing with thousands of applications which continue to be lodged as a result of deficient execution. But where the root cause of a systemic problem at national level remains untreated, the court continues to receive applications, often in their hundreds or thousands, and continues to find violations which stem from that systemic or structural problem, thus creating a vicious circle with negative effects on the effective functioning of the Convention system. I think, for example, of the case of Bermich and others against Ukraine, handed down by the Grand Chamber after 14,000 judgments and decisions had been already rendered by the court on non-execution of domestic court judgments. The court transferred 12,000 cases to the Committee of Ministers, and I'm sure this case will form part of our discussions during the day. As the court pointed out in the memorandum for the Reykjavik summit, the present situation is unsustainable, both from the perspective of the principles of subsidiarity and shared responsibility, and from the perspective of a court seeking to respond sufficiently quickly to the new and difficult questions to which changes in our societies, democracies, climate, and conflict give rise. As I emphasized in my introduction, the rule of law is one of 3 pillars on which the Council of Europe and the Convention system are based. It is also a value now enshrined in Article 2 of the Treaty on European Union. Needless to say, when it comes to respect for the rule of law, what happens in Strasbourg is monitored very closely in Luxembourg and Brussels, and vice versa. When adjudicating cases relating to the independence of the judiciary or the operation of mutual recognition instruments such as European arrest warrant, the Court of Justice refers extensively to the well-established case law of the Strasbourg Court on Article 6. Indeed, the extent to which the spirit of the Golder judgment, handed down by the Court in 1975, is reflected in the recent conditionality judgments of the Court of Justice in annulment actions brought by Poland and Hungary is quite striking. As the Luxembourg Court has developed its case law in relation to Articles 2 and 19, paragraph 1 of the Treaty of European Union and 47 of the Charter, clear synergies can also be seen in Strasbourg Court references to the Luxembourg Court's case law. Beyond interaction between the 2 European courts in defence of the rule of law, the European Commission, in its assessment of EU member state compliance with Article 2 values and the rule of law, looks to their Convention record. This makes perfect sense if one looks back to the early 90s and the dramatic geopolitical changes which Europe was undergoing, with new democracies emerging on the doorstep of the newly baptized European Union. EU accession criteria firmly anchor conditionality into the accession process, with the newly added Articles 2 and 7 of the TEU designed to encourage adherence thereafter. New member states, and indeed older ones, are required to ensure the stability of democratic institutions, the rule of law and human rights. Membership of the Council of Europe and ratification of the Convention are key in this regard, because in the words of one EU legal commentator, it's the task of the European Court of Human Rights among other international institutions, to keep European legal orders in check. 5 EU member states still feature on the Strasbourg Court's top 10 list of states ranked per number of pending applications. 2 feature in the top 5. In its annual rule of law reports since 2022, the Commission refers to the execution of judgments of the European Court of Human Rights as an important indicator of the functioning of the rule of law in the EU member states surveyed. And the same indicator will presumably be of paramount importance for 8 members of the Council of Europe, which are now candidates for EU accession. My purpose here is not to address in detail rule of law synergies which have successfully developed between the EU and Council of Europe systems, but rather to highlight the type of centrifugal tensions and consequences that failures by states to execute Strasbourg Court judgments create both within the ambit of the Convention system and beyond. So what has been done so far to address deficient execution of the Court's judgments? At the political level, the critical problem of deficient execution has been highlighted time and again. In the Reykjavik Declaration mentioned by President Lavins in May, the heads of state and government acknowledged that the primary responsibility for ensuring compliance with international legal obligations to which member states have sovereignly committed is borne by domestic, democratic and judicial systems. They recommitted to the binding nature of the Court's judgments, and I will add decisions, and to redoubling their efforts for the full, effective and rapid execution of judgments, which they considered of fundamental importance, and I quote, to ensure the long-term sustainability, integrity and credibility of the Convention system. It's hoped that one of the fruits of the 4th Summit will be the development of more cooperative, inclusive and, where needed, a political approach to execution based on dialogue between states and relevant Council of Europe institutional actors. And there's clearly room for further strengthening of synergies, for example, between the Registry of the Court and the Department of Execution of Judgements. In this respect, at a seminar organised at the Court in March, different execution, what I would call stakeholders, judges, ambassadors, staff from the Execution Department, members of the Committee of Ministers Secretariat and the Court's Registry were brought together to look at ways to promote this. At judicial level, the deficient execution of the Court's judgments can be, and indeed is, tackled both at Strasbourg and national level. At Strasbourg level, over the course of the last 20 years, the Court has assumed more responsibility in the execution process, notably by giving indications as to the specific individual and/or general measures to be taken under Article 46 in order to put an end to a situation which it has found to be in violation of the Convention. As of June 2023, more than 300 judgments contained such indications. The Court's practice is intended not only to guide national authorities, but also seeks to facilitate the Committee of Ministers' role in supervising the execution process, bearing in mind that the ultimate choice of execution measures to be taken remains within the margin of appreciation of the states concerned, provided, I add, that the conclusion and spirit of the judgment of the Strasbourg Court is respected. I wouldn't wish to take too much of your time on the specificities of individual measures. A good case in point is a case called HF and others against France, concerning the refusal of the French authorities to consider a request to repatriate French nationals detained in camps in Syria. After finding a breach of Article 3, paragraph 2 of Protocol 4, the Court indicated that the French government had to re-examine those requests in a prompt manner while ensuring that appropriate safeguards were afforded against any arbitrariness. With regard to general measures, the Court may find it useful or even necessary to indicate them where it has found that the violation of the Convention is occurring or is likely to occur in similar situations. Accordingly, the measures should be such as to remedy the Court's finding of a violation in respect of the existence or non-existence of legislation or even a general practice, so that the system established by the Convention is not compromised by a large number of repetitive applications stemming from the same case. The dynamic nature of the Court's review is implicit in the pilot and quasi-pilot judgment procedures, to which I want to turn for a moment. In the context of these procedures, the Court remains in control of the supervision of measures taken at the domestic level to address the deficiencies identified in the pilot or leading judgment. The adequacies of the measure adopted is not under the sole scrutiny of the Committee of Ministers, but also under the judicial scrutiny of the Court, and the standards used are that of Convention legal requirements. And we've seen how this works in cases like Torrigiani and others against Italy, or Valianu and others against Romania. The emphasis in these cases is shifted from the Court's adjudicative role in individual cases to its constitutional role, which is to clarify Convention obligations, protect the achieved level of Convention rights and freedoms, and, where needed, further develop Convention standards. A more extensive use of pilot and quasi-pilot judgment procedures has the potential to be an effective tool to tackle the problem of the high number of cases currently pending before the Court, by identifying the cases of constitutional relevance and dealing with other repetitive cases in a more summary way. And the Court is currently in the process of internal reflections as regards further enhanced use of these procedures. Any effort in the execution of the Court's judgments critically depends on the involvement of you, national judges and national courts. They must act as faithful guardians of Convention standards and values. They have the task of ensuring that the Convention is duly implemented in their domestic orders. However, at national judicial level, as I mentioned before, a varying degree of reluctance in executing the Court's judgments may stem from reliance on member state constitutional traditions or identity. It is, however, important to remember that cases of open conflict may be high profile, but they are relatively rare. On the contrary, the strong and continued institutional dialogue between the Strasbourg Court and national superior courts continues to bear fruit. For the role of national judges when it comes to execution, the aftermath of recent French and Latvian cases provides a good illustration. In a case called JMB and others against France, decided in 2020, the Court found a violation of Articles 3 and 13 on account of inadequate conditions of detention in certain French prisons and the lack of effective remedies available to prisoners. In July of the same year, the French Court of Cassation explicitly relied on the JMB judgment and found that even before the requisite legislative changes were made, French judges should be able to put an end to conditions of detention contrary to Article 3. A few months later, the French Constitutional Court, on the basis of a priority preliminary ruling requested by the Court of Cassation, decided to repeal the relevant provisions of the Code of Criminal Procedure. This timely sequence of judicial dialogue between the Strasbourg Court and the French Superior Courts culminated in the adoption, a few months later, of legislative amendments seeking to comply with the JMB judgment. As regards Latvia, the case I'd like to mention is a case called ECHR against Latvia, and I'm sure my pronunciation is very poor. The case concerned a blanket ban on prison leave for male prisoners in maximum security prisons without any individual assessment of the proportionality of such a prohibition. A majority of the Chamber found a violation of Article 14 in conjunction with Article 8. The case was closed by the Committee of Ministers in September 2022, following an amendment of the Code for the Enforcement of Sentences. In the same year, a further amendment introduced the possibility to grant compassionate leave for up to 2 days. And I'd like to emphasize that following the judgment of the Strasbourg Court, and before the relevant legislative amendments, the Constitutional Court of Latvia had found that the provision of domestic law, which precluded all prisoners serving their sentences in closed-type prisons from requesting compassionate leave, was incompatible with the Constitution. Lastly, and this touches on a point raised by President Lavins in his introduction, allow me to note that in terms of the role of national judges when it comes to execution and subsidiarity, Article 46, paragraph 1 is not the only relevant provision. There is also the res interpretata effect of court judgments for courts and authorities in states other than those which are party to proceedings. This is one of the most important tools reinforcing subsidiarity, but also limiting the number of applications before the court. In conclusion, and I look to the timekeeper to ensure that she feels calm, the success of the convention system has been achieved through a combination of efforts both domestically and at international level. Implementing the convention must be a joint effort of governments, parliaments, domestic courts, civil society, and of course the judges in Strasbourg. I stand before you today as a president of a human rights court which currently has some 75,600 pending applications, 80% of which, as I said, are repetitive cases or cases in relation to which the case law is well established. Tackling the related question of the docket and execution is critical not only for the sake of individual applicants, but also for the long-term health of the convention system and its ability to tackle the many grave and new challenges to respect for human rights, democracy, and the rule of law emerging in our societies or on our borders. Thank you very much for your attention.
O'Leary kundze, paldies.
Madam O'Leary, thank you for this very extensive and elaborate presentation in which you examined, I have to say, quite a number of challenging aspects. I will just highlight some of them. First of all, it seems to me quite important to remind that if the court's rulings are not executed, then the integrity of the judicial system is undermined. I really thank you for the good words addressed to Latvia. Since the attitude of Latvian authorities towards execution of judgments by the European Court of Human Rights is very positive, and we don't see systemic problems. So apparently internal mechanism exists for executing the judgments, and in this mutual dialogue between the judicial power and the executive power and the legislators, these problems are being resolved. And apparently, this is the outcome. We see this positive assessment. And I would also underscore this, what you said in your speech, the need for a dialogue. And you used two examples to illustrate it, to illustrate how problematic situations or situations where you see certain tension, for example, I heard or I noticed certain tension between the German courts and the European Court of Human Rights, that through dialogue and through loyalty, such problems can be resolved and problems can be prevented. And the other example, which I noted, was related to France. And I should also underscore the following aspects, those pilot judgments. This is a tool that helps to reinforce the rule of law because it is an effective measure how to deal with the workload of courts. And I know that also within the national system here in Latvia, we are applying this tool more often and we see results. And finally, and I also have to compliment you for giving a very structured overview of the obstacles really for in executing judgments of the European Court of Human Rights, political opposition, practical and financial considerations. And I here come to the next consideration. I will continue with this. You spoke briefly about the way how, on the national level, the argument regarding constitutional identity is used as an additional reasoning why, on the national level, some kind of exceptions should be made. Exceptions to application of the findings expressed in the judgments of the European Court of Human Rights. I believe this is a very important matter because we are speaking about important values enshrined in the Constitution. But at the same time, we have to keep in mind that we have the International Court, the European Court of Human Rights, which task is to pass judgments that would be enforceable in all member states of the Council of Europe. So how to combine these two very important values? Madam Ziemele a very difficult task for you to give your view on how constitutional identities are used or applied when we deal on the national or on the international level with matters of application of law. The floor is yours.
Excellencies, colleagues, ladies and gentlemen. In fact, my speech could be the shortest ever at such occasions, because all that needs to be said is that the execution of judgments forms an element of national identity in states based in rule of law. So, in fact, there is no conflict. There can't be a conflict, provided we agree that national identity is not limited to culture, language, and the main historical narrative of a nation, but that it also captures democracy and rule of law. I think there is a good reason not to take solely a sociological approach in comprehending what national identity is. Because for our purposes, national identity, at least in some part, is defined by constitutional law, as it is constitutional law which defines national symbols and takes stock of particularities of social contract of each society. In some constitutional doctrines, national identity may legally be defined through the perspective of the so-called constitutional identity, indeed, and in others as a general principle of constitutional law. One way or another, every now and then, constitutional jurisdictions may need to engage with elements of national identity embodied in constitutions concerned. Every now and then, states use arguments, indeed, that execution of judgments cannot take place since it would be contrary to their national identity. These arguments are familiar at European and national levels, including Latvia. Upon a more profound reflection, therefore, the matter is not trivial, it's not simple. It does merit a serious discussion. Let me briefly introduce the factors that have contributed to the evolution of the unease in the relationship between national identity and courts, which is reflected in the difficulties or opposition to execution of judgments of the European Court of Human Rights, the Court of Justice of the European Union, and on some occasions, albeit more rarely, constitutional courts. First, it is the overall digital age in which we live. It has the incredible capacity to inform, but also to misrepresent. Second, globalization, an age of crisis, which triggers considerable insecurity in any human society, and the way the societies next to the aggressor state feels was already transmitted by both presidents of the highest courts of Latvia. That is a more fertile ground for national rather than European or international feelings. Third, very different historical narratives in Europe, and the lack of their knowledge within a space which claims to be more united than other spaces in the world. I have a habit to ask my colleagues around Europe, how much of history of the Baltic states you have learned at school? Finally, we also live in the age of incredible judicialization of human relations. Where there is a disagreement on common values, we can agree on one thing, namely that we go to a third party and in a fair procedure determine who is right and who is wrong. We accept the result because we trust the procedure. That happens to steal a limelight from political processes, and that too may be problematic, at least from the point of view of politicians. The courts with the competence to determine value disputes, and the courts which adjudicate human rights are such value courts, have become important contributors to social processes, and that is rather different from what was the originally perceived role of judges, as per Rousseau and Montesquieu, who wanted to have the judges to be only a mouthpiece of law, although they knew that that was not possible. Now, I think the nature of a society is such that all societal organizations and institutions contribute to an ongoing self-constituting process of each society. And the courts are no exception. The courts contribute to that process. I think it is only honest, and it has to be recognized, and it has to be catered into our intellectual reflection. Now I will address in some more detail the key notions that are relevant for this very challenging topic. Now, I do have to speak about the principles that underline the notion of execution of judgments. And then I will investigate the proposition that execution of judgments forms part, of course, of rule of law, but as such, national identity of a democratic rule of law based state. And I will ask in the end whether there are any legitimate considerations pertaining to national identity that may conflict with the rule on execution of judgments. It is also important to point out that we need to be clear as to what we are talking about when we refer to execution of judgments. Is it about execution of operative part? Is it about execution of operative part and the motives? Or is it the compliance with the case law? And there I will refer to erga omnes character of what I believe is the character of the case law of the European Court of Human Rights. Now, I start with Article 46 of the European Convention on Human Rights, of course, already referred to by the President O'Leary. Now, Article 46 provides for the obligations of states parties to the Convention to execute judgments of the court and sets up the mechanism for that purpose. And it really, we should not in Europe, as Europeans, lose sight of the fact that if approached from a world perspective, the European mechanism of execution of judgments, in fact, is a great achievement and the most complete mechanism that you can have as concerns of the execution of international judgments, of the judgments of an international court. Now, that mechanism has to be looked at against the rule on state responsibility in international law. And according to the mechanics of state responsibility, a violation of the convention established by the Human Rights Court is an internationally wrongful act, and as such, it must be repaired. That requires that a wrongful act receives a full reparation of the injury caused. Now, reparation is intended to make the party injured by the illegal act whole and place it in the same position as it would have been had the breach not occurred. Over the years, it is also important to keep in mind, the convention mechanism has moved to, in fact, fully embrace the very idea of state responsibility, because I mean, originally, if you look at Article 41 on just satisfaction, originally the mechanism was based on the idea that the states will comply with the judgments at a national level. And it is only as a fallback option that if the states do not do that, if there is no restitutio in integrum, then the court will go on, or the execution mechanism will go on and provide for guidance as to what the full state responsibility should look like. Now, the Convention presumes good faith and compliance with the principle of pacta sunt servanda. Now, along this logic, Article 46 has come to embrace various mechanisms, such as was mentioned, general measures, individual measures, pilot judgments, even the advisory procedure that is available right now, to fully embrace restitutio in integrum obligation on the member states. I would say within a very short period of time, as far as human history is concerned, execution of judgments in the convention system has matured considerably, and that we already heard from the President already. That said, in its very essence, the success of the system continues to depend on the good faith of member states, either when they execute the judgments on or when they exercise the peer pressure in the Council of Europe political bodies. And that is really possible only if there are like-minded states. Now, like with the execution of the judgments of the constitutional courts, I'm trying to jump because I have very little time, but yeah, there we are. Latvia has been a very open state in with regard to the compliance of the judgments of the European Court of Human Rights. In fact, if you look at the practice of the Latvian courts, you see that it embraces not only operative part, not only the motifs, but also the case law as such. And I would say Latvia is a front runner in embracing the idea that the judgments of the court have the erga omnes character. However, if we look at the case law of the court, and if we look at the approach by the other government bodies in Latvia, I would say there is a place for a better mechanism with regard to execution of judgments in the executive and parliamentary levels. I will give you an example. Opus case from 2009 on domestic violence, where the Human Rights Court gave very detailed prescriptions as to how the domestic violence should be dealt with at national levels. 2023, Latvia is shocked by a very similar event of domestic violence. Now, if we were to follow in good faith the judgments of the European Court of Human Rights, we would take the principles of Opus case and we would have, since 2009, established a number of mechanisms within the law enforcement which would have avoided and prevented such tragedies. What it takes is to take the recent press releases of the European Court of Human Rights, to have a central institution, probably at the level of state chancellery, which goes through the press releases and identifies exactly the steps and adopts against the Latvian law what is there and what is not there. Such a centralized body with regard to the Human Rights Court, with regard to the Constitutional Court's judgment, would be of great help, the body which has a horizontal view of the whole executive branch of the country. So while the courts certainly in Latvia embrace and ergo omnes character of the case law, I still see that there is a lot of things to do when it comes to sort of preventive and executive action. Now, from a constitutional law perspective, execution of judgments, I refer to international law perspective, now constitutional law perspective, is a crucial element of rule of law. It actually gives meaning to the principles of separation of powers and checks and balances. If the government was allowed not to execute judgments of the courts, including European courts, that would infringe the very idea of separation of powers and checks and balances. And such practice greatly undermines democracy and is a sign towards its backsliding. From the perspective of the minimum human rights standards explained by the Human Rights Court, the execution of judgment surely is part of the right to a fair trial. And it ensures the principle of legal certainty. Now, indeed, there is a synergy between the Court of Justice and the European Court of Human Rights as concerns the scope and content of the right to fair trial, because what the Court of Justice does, we apply the rule of law principle enshrined in Article 2 of the TEU. Now, that said, how that caters into the notion of national identity. National identity is an abstract and, as I said, rather open-ended notion. Latvian constitution spells out in the preamble of the constitution that Latvia is a nation state which is formed of Latvians and Leaves and all of the citizens, and that in Latvia democratic discourse takes place in the Latvian language. Now, the interplay and balance between all relevant principles, including the principle of a nation state and the rule of law, in fact, is set out in paragraph 4 of the Latvian constitution, and I quote, "Latvia as democratic, socially responsible, and national state is based on the rule of law and respect for human dignity and freedom. It recognizes and protects fundamental human rights and respects ethnic minorities, etc." So a priori, as I started, and I'm going to my conclusions as well, it is hard to imagine any conflict between values of a democratic nation state and rule of law, which includes execution of final judgments of national and European courts. It is also difficult because, as already mentioned, the European Convention allows for national particularities. It has the margin of appreciation mechanics when it comes to the compliance with the Convention rights. In fact, the European Union in Article 4.2 of TEU protects national identities as they are embodied in constitutional structures of the member states. Now, there are, however, different scenarios and two groups that I would like to identify where the confrontation has happened. There are instances where, in fact, the principles of primacy of one or another legal order, or pacta sunt servanda, on the one hand, and sovereignty of adjudication are confronted. I submit that this type of scenario is among the courts to solve, be it the Court of Justice and national courts, be it the European Court of Human Rights and national courts. That is something to be solved in a dialogue between the courts. The second constellation is really much more complicated. There are not many cases, but it still exists. And it is in the second constellation where, in fact, there is a clash of values. There is a genuine disagreement as to the scope of values. And as said, it is indeed a serious matter. Now, my sort of analysis and propositions as regards, and simply based in my experience by now in 3 courts. You see, it really requires, from all 3 courts concerned, as it may be in the context of one case, a genuine dialogue in good faith of all of the stakeholders. Now, from the perspective of the European Court of Human Rights, I would say the principle of subsidiarity is important in genuine cases of disagreement on values. I would mention animal defenders, I would mention against the United Kingdom, I would mention SAS, contre la France. These are cases of constitutional identity, parliamentary rule in the UK and secular state in France, and the court has been able to really address these cases well. From the perspective of the Court of Justice, it is also possible to genuinely understand such difficult situations. Look at Omega judgment, look at recently Tsilevich and others judgment that came from the Latvian Constitutional Court. Now, all these judgments to me exemplify the importance of sensitivity towards national particularities embodied in the notion of constitutional identity. And they are presented through the dialogue of courts in good faith. To sum up, the principles of democracy, rule of law, protection of human rights are intertwined. They are meant to be in balance. And I think the balance today is more striking to us than ever before. Because with the war in Europe, we realize that we cannot take for granted neither these 3 pillars nor the fact that they ought normally be in balance. And I think it is quite important also to keep in mind and be honest about it. Individual rights are not absolute, with some exceptions. The right of a democratic majority is not absolute. And the judges are not always right. We have to be honest about these realities. Now, strengths of our common European values is discovered through their interplay and dialectics. And balance can be different in different societies due to their histories, cultures, geography, as long as minimum European core, as determined by the human rights, is universally guaranteed. In the end, I come to the sentence that I started with. National identity cannot be confronted with the rule of law and its core element, execution of final binding judgment. The latter is part of national identity in the Council of Europe member states. It is imperative, however, especially for the courts that are removed from national narratives and identities, to listen carefully to the explanations and arguments provided by the parties. As I said, protection of national identities, too, is a European value. But so is the membership in common European human rights architecture, which is meant to offer, among all of this complex dialectics, the strongest protection to European individuals and European nations today. And so it is a very difficult work for every one of us. Thank you.
Ineta, paldies.
Thank you, Ineta. Thank you for this insight into this extremely complicated issue. I have been also dealing with it, and I know how complex it is. Now, after this presentation, I would like to highlight some aspects. And the one thing that I noticed was this very precise statement that, in fact, there is no conflict between the rules on execution of judgment and the national constitutional identity. And this is linked with the proposition that we really have to look at this. If the European Court of Human Rights has found an infringement, a violation, this means that this is an act that it's unlawful. So which national system in its identity could go contrary to this fact that an unlawful act and its effects must be prevented? And I would also like to thank you. Whenever we speak about execution of judgments and also understanding of constitutional identity in this context, we always have to understand how we look at this execution, whether we are speaking about operative part of the judgment and reasoning, and also the findings expressed in the case law in their totality. So this was a very brief summary, but according to our agenda, Vasaka Chali, Professor of International Law, has now the opportunity to provide her rejoinder on what was just heard in the presentation by respected Madam Zemele. So the floor is yours for the rejoinder.
Thank you very much, President, dear Judge Presidents, dear esteemed judges, dear colleagues. Thank you for inviting me to provide a brief rejoinder to these very important discussions at the opening session. So a rejoinder is often understood as a reply, and it's preferably something a little bit sharp, a little bit witty, and it's meant to be very short. I know it's about 5 minutes, but I must say at the outset that I am very much in very strong agreement with quite a lot of the things that have been said so far. So it is a difficult challenge to offer a counter argument or a counter reply. So what am I in overwhelming agreement with what has been said? And this is the point that both President O'Leary and Judge Zemele have just made, that we have to put the implementation, the execution of the European Court of Human Rights judgments at the heart of understanding the authority of this system, the sustainability of this system, and the future of this system. I could not agree more. So how could I reply? That's a challenge. But of course, I'm aware that I should say something a little different. If I say I all agree, I think that's 5 minutes wasted of your times. So what I'm going to do is perhaps give 3 additional insights or give 3 additional critical points to add to these conversations. And in so doing, I'd like to also make some concrete recommendations, perhaps that might be helpful for the discussions that are coming up. So the first point is that relationship, that we are not talking about execution for the sake of execution. The execution of the judgments of the European Court of Human Rights is about the health of the system. So I think that link could not be overemphasized. And you might all agree, which will be fantastic that we all agree, but we also have to understand that this is a point that we have to repetitively make. So, and there are many important reasons for why this has to be this is the case. So the Latvian chair persons have made this a priority since May, and of course in the Reykjavik Declaration, this was also a priority for the European system. But I think one concrete recommendation that I will have is that this is a fixed priority. So even after the Latvian chairpersons, when it moves to the next countries, the Luxembourgs, I don't think this is a priority of a choice. And I think it has to remain a fixed agenda item for every session of the Committee of Ministers. But I'd like to take it perhaps one more step further, and I also want to interject the second idea that interpretation of Article 46 as a living instrument must also be a priority in all exchanges between the European Court of Human Rights and domestic courts as well. I have a feeling that we talk a lot about substantive case law of the court. Of course, this is very important, but Article 46 is not a footnote provision of the Convention, and we have to understand its living instrument nature as well. So this links to my second point. It seems we all agree about Article 46, that the court judgments are binding and they have to be executed. I think there's a danger in presenting this as a very simple idea that we all agree. I do agree that it sounds very straightforward, but Article 46 is a living instrument, and its jurisprudence has been developed extensively, in particular by the Committee of Ministers of the Council of Europe, and as Judge President O'Leary highlighted, perhaps less so by the European Court of Human Rights. So one of the key areas of recommendation would be that we have to very closely engage with the remedial jurisprudence that has been also developed by the Committee of Ministers. And there are big challenges because judges are used to study the case law of the court, take that into account, but there are some important questions about how we actually look at the remedial jurisprudence of the Committee of Ministers. And this is one area I think we need to think further. My last observation and point has to do with individual measures. Judge Ziemele also pointed out the distinction between individual and general measures. And I think domestic judges play a very different role in the execution of individual measures as opposed to general measures. There is no chance of renegotiating, as also was highlighted by the President just a minute ago, what individual measures are required in individual cases. And of course, here the remedial principle of Article 46 as a living instrument is reinstitution to the situation prior to a violation. This is what guides the judge, the Strasbourg court, and it is also what should be guiding all domestic judges. So obviously, the individual measures cannot be filtered through arguments around constitutional identity or any other types of arguments that may actually conflict with this principle of restitution ad integrum. So I hope these three recommendations or ideas were helpful, and I look forward to more in-depth discussions throughout the day. Thank you.
Paldies.
Thank you, Madam Chali, for these three recommendations or three ideas that could facilitate understanding of this very complicated matter. I have to say that according to the agenda of our first plenary session, we have no time allocated for discussions, but this does not mean that we won't have the possibility to discuss these matters. At the very end of the conference, we have some time for discussions, and we will have the possibility to debate. So now let's proceed. Already in the presentations given by the first speakers, Madam O'Leary and Madam Ziemele, we heard several times references to the need for a dialogue as a tool, for resolving possible, I wouldn't say conflicts, but perhaps tensions between different legal systems, how to resolve these. I see that our colleague Madam Zilli has prepared her presentation on this issue. The emphasis, as I understand, will be placed upon the dialogue between the European Court of Human Rights and the Committee of Ministers. Not the dialogue, not the vertical dialogue, but we might say dialogue on a horizontal level, the way I understand it. But let's give the floor to the speaker and let's understand what kind of dialogue she will discuss and how it will promote reinforcement of the rule of law. The floor is yours.
Thank you, President Lavins. Excellencies, distinguished guests, let me start by thanking the Latvian authorities for organizing this important international conference and for their very warm hospitality here in Riga. It's my real pleasure and true honor to address you here this morning on this very important topic. I will start by quoting the words of Ambassador Karklins in the preface to the annual report on the execution of the court's judgments. There can be no more powerful commitment to the multilateral system and the Convention values than by ensuring all judgments of the court are executed. I could not agree more. Indeed, the judges of the Strasbourg Court specifically called upon member states in their memorandum for the Reykjavik Summit, the historic fourth summit of heads of state and governments, to reaffirm their commitment to the binding nature of the court's judgments and decisions. The Latvian presidency of the Committee of Ministers, which has set as one of its priorities the implementation of the decisions taken at that summit, comes at a critical junction in the history of the Council of Europe. Obviously, I'm referring here in particular to Russia's war in Ukraine, its subsequent immediate expulsion from the Council of Europe, and the consequent implications for the European Court of Human Rights and its work. In addition to conflict, challenges to the Convention system and to a liberal, rules-based order can also be witnessed as a result of a general democratic backsliding. Your task is not an easy one, and the role of the Council of Europe is more important now than ever. Appendix 4 of the declaration adopted in Reykjavik recalls that executive, national and local authorities, national courts and national parliaments bear responsibility for implementing the Convention and complying with the judgments of the court. Your conference today, in the presence of judges of constitutional and Supreme Courts, explores the particular role of national courts in the execution of the judgments of the European Court of Human Rights. I think that the message you are sending is a very strong one. Human rights protection for all Europeans is and should be our collective concern. Judges and courts are also important actors in the implementation process. What is your role in that process? How can you better perform that role? These are the questions which you will be exploring today, and particularly in the breakout sessions later. Before I begin discussing the role of national judges in the execution process, let me touch upon how we, at the European Court of Human Rights, value and promote actively the role of national judges within the Convention system, a system which is based on shared responsibility, which means in very simple words that the Strasbourg Court is not the only one responsible for protecting and promoting human rights in the European legal space. It shares this responsibility with the member states, which in turn means that the Strasbourg Court is not the primary human rights judge. It's each judge sitting in his or her local court that it's the first human rights judge. Let me explain. Because of your direct and continuous contact with the vital forces of your countries, the European Court has repeatedly stated that domestic authorities are better placed than an international court to assess the multitude of factors surrounding each case. It is therefore basically for you, domestic judges, to identify and afford redress for possible infringements of human rights in each particular case. And in this way, you have both a preventive and a corrective role to play. By applying the European Convention at the domestic level, you act as a Strasbourg court judge in your own country. If convention rights have been effectively taken into account at the domestic level, there is often no need to come to Strasbourg, or if the application does come, the court is able to deal with it in a less analytical way. It's a win-win situation for the parties to the proceedings and for us at the courts. For this reason, a crucial aspect of the work of the court is to enhance judicial dialogue with national courts. Judicial dialogue takes a number of forms. Let me start by the advisory opinions, whose aim, according to the preamble to Protocol number 16, is to enhance the interaction between the court and the national authorities. Indeed, the aim of the procedure is to provide assistance to member states so as to avoid future violations, facilitate the correct interpretation of the Convention within national legal orders, and in this context, enhances judicial dialogue. Since the entry into force of Protocol number 16, the Court has delivered 7 advisory opinions. The Court is organizing a half-day seminar on 13 October to mark the 5th anniversary of the coming into force of Protocol number 16, and all Supreme and Constitutional Court presidents have been invited. The idea is to exchange views on the protocol from a national and international perspective, to see what is working well and what could be improved. I know that we will see a number of you in Strasbourg on that occasion, and I would also like to thank you for supporting this event. However, despite its non-adversarial nature, this procedure requires time and resources. First, for the request to be accepted by the panel of the Grand Chamber, and then for the Grand Chamber to deliver the advisory opinion. It therefore cannot be expected to be used as a matter of routine. This is where other tools of dialogue come into play. And I'm thinking, of course, of the Superior Courts Network, which the Court established in 2015, and which now counts 104 member courts from 45 member states. As such, it has become the largest Superior Court network in the world, and we are very proud of it. The core objective in creating the Superior Court network was to provide concrete operational support to the national jurisdictions and to offer member courts a channel of communication whereby the European Court explains its jurisprudence in real time. National courts, in turn, provide our court with insight into their respective jurisdictions, making valuable input in our comparative work. I'm sure you're all familiar with the work of the Superior Court Network, but I would like to share with you a new chapter in this journey, which is our visiting professional scheme. We have started receiving a group of professionals from the registries of our member courts to share our know-how in case processing, document management, knowledge management, as well as IT tools. These visits to the court are already proving very popular, and I would invite you to explore this possibility. The Superior Court Network is really subsidiarity in action, thanks to the human contact it enables and various features, notably the knowledge-sharing platform. This platform has been a cornerstone element of judicial dialogue within the network, but nowadays its impact is going far beyond the Superior Court Network and the Judiciary. On 18 October last year, I had the great honor, together with the former President of the Court, the Deputy Secretary General of the Council of Europe, and the Director General of Human Rights and Rule of Law of the Council of Europe, to launch the external knowledge-sharing platform in both official languages of the Court, French and English. We believe that this free access to all legal professionals, judges and lawyers, transform the dissemination of the knowledge about the court's case law. Our plan for the coming years, budget permitting, is to duplicate it in a number of non-official languages. Operating in a broader context, the Superior Courts Network and the Knowledge Sharing Platform are two of the three components of the joint project of our court with the Directorate General of Human Rights and Rule of Law of the Council of Europe, called Enhancing Subsidiarity. The third component is directly focused on the national courts. We are developing BRAND, which means Broad Rights and Navigation Tool, which aims at integrating the knowledge sharing into IT tools employed by national judiciaries and will serve as a means for an early identification and classification of human rights issues based on the Convention. It will thus assist national courts with case management in a Convention-compliant manner. Finally, another important manifestation of judicial dialogue is the Court's annual judicial seminar. It gathers together presidents of the Constitutional and Supreme Courts of Council of Europe member states for a half-day of discussions on a chosen theme. This event is one of the most important in the Court's calendar. Our next seminar, which will take place on 26 January 2024, will look at the notion of subsidiarity in the age of shared responsibility. This should be an extremely relevant topic, and we already have 4 excellent speakers. However, I should stress now that judicial dialogue does not just take place with judges from superior courts. The Court welcomes delegation of judges from all courts across the Council of Europe legal space. These are not simply courtesy visits. They are of great importance for the sustained legitimacy of the Convention system and have been organized within the context of Council of Europe cooperation projects on raising awareness about the Court's judgments. The Court provides a training program which includes meetings with court judges and registry lawyers, the opportunity to attend a public hearing where possible, and to see firsthand how the Court works. Of course, the most important manifestation of judicial dialogue occurs through judgments of the Strasbourg courts and national courts in the field of convention rights. This takes me to the next part of my intervention this morning. How does the Court converse with national judges in implementing the judgment of the Court? It has already been said, but I would like to repeat that according to Article 46, paragraph 2 of the Convention, the final judgment of the Court shall be transmitted to the Committee of Ministers, which shall supervise its execution. It is the Committee of Ministers' responsibility to ensure that the judgment is fully implemented by the respondent government. But the mere fact that the Convention itself establishes such a mechanism emphasizes the importance of the effective implementation of the Court's judgments. Let me begin this third section of my intervention by underlining an important point. Overall, the implementation of the Court's judgments is a successful process. In 2022, the Committee of Ministers closed 880 cases, of which 200 were leading cases. It is true that there are more judgments pending full execution now than there were a year ago. One reason for that is that the Court is transmitting more judgments for executions to the Committee of Ministers, so we are more productive, and many are complex cases as a result of our impact strategy having an effect. For those of you who are not familiar with the notion, what is that strategy? We were aiming for a court that matters, and therefore we have put in place a more targeted and effective case processing policy. It builds on the priority policy, which has already been in place since 2009. Impact cases do not concern core rights, like rights protected by Articles 2 or 3 of the Convention, but are prioritized cases that raise important legal issues of relevance for the respondent state in question or for the Convention system as a whole. The purpose of this strategy is to ensure rapid identification and more expeditious case processing than was previously the case. As said, and I will not stop repeating it, it's the Committee of Ministers that is competent for the supervision of execution. But that being so, the Court has now a well-established practice of indicating in certain cases what type of execution measures it thinks would be useful. Even in cases where there are no Article 46 indications given by the Court, individual and general measures are still needed, are usually needed. Because execution measures must first put an end to the violation, as Judge Zimmele said, and remedy as far as possible its negative consequences for the applicant. And these are the individual measures. Execution of judgments also requires general measures to prevent violations similar to those found by the Court, whether through changes of legislation, case law, or through other kind of measures. One of the fastest and most efficient ways to ensure the execution of the Court's judgments has been for the judicial authorities to give them direct effect, implementing them without the need for legislative changes. Indeed, it is sometimes easier for national courts rather than parliaments to make the changes needed, depending, of course, on the legal systems put in place in each country. As noted by the Department for the Execution of Judgments in their thematic fact sheet on constitutional matters, many constitutional courts have interpreted domestic law, including the Constitution, in a convention-compliant manner in the context of the execution of the Court's judgments. Here I will not be speaking of the issue of reopening of domestic judicial proceedings per se. We will discuss that later. The fact sheet I just mentioned gives a wealth of examples under different themes, for examples regarding asylum, detention, the efficient running of justice, protection of private life, freedom of expression, and association. In these cases, constitutional courts or Supreme Courts have taken decisions to align their domestic case law with that of the European Court of Human Rights. Let me give you a couple of examples from concrete cases. Each case started with a judgment from the Strasbourg Court finding a violation of the Convention. Then, a superior domestic court issued a judgment aligning with that case law, and then a final resolution of the Committee of Ministers closed the supervision of the case. The first case I will refer to is a Spanish case from 2018, which concerned expulsion orders against 2 Moroccan nationals following their convictions for criminal offenses in Spain. The question was whether the expulsion orders were necessary in a democratic society under Article 8 of the Convention. Our court found that the national authorities had failed to examine the nature and seriousness of the criminal convictions in question, as well as other criteria established by its previous case law, in order to assess the necessity of the expulsion and exclusion orders. Then, the Supreme Court of Spain adopted 2 important judgments which incorporated the principles affirmed by our court, therefore aligning its jurisprudence on the application of the domestic law to the case law of the European Court of Human Rights. Therefore, in Spain, if you have 2 judgments from the Supreme Court which establish, this is considered to establish case law. Therefore, the lower courts must follow it. This fact permitted the Committee of Ministers to consider that the matter was closed and close the supervision of the execution of the judgment that our court had issued 2 years ago. My second example concerns a Slovenian case whereby the applicant company, which was a publisher, was complaining before our court that it was ordered to pay damages to a parliamentarian for insulting him in an article concerning a parliamentary debate on the legal recognition of same-sex relationships. Our court found a violation of Article 10 because it thought that the Slovenian courts had failed to strike a fair balance between the publisher's right to freedom of expression and the parliamentarian's rights to protection of his reputation. The Slovenian Constitutional Court changed its case law when deciding on similar constitutional complaints. The matter was then considered closed also by the Committee of Ministers. There is a third case, which I don't have time to refer to. But what do these examples show us? That many constitutional courts have interpreted domestic law, including their own constitution, in a convention-compliant manner, and thus played a crucial role in the execution of the court's judgments. In some cases, of course, this may not be possible, but when it happens, it's a fine example of how our two courts interact. And I arrive now to my conclusion. Full execution of the court's judgments, it's not just important for the application, for the applicant in a given case, nor for our backlog. It's mainly important for the credibility of the system as a whole, for which, as I said, we are all responsible. This is why the message from today's event is a very important one. The duty to execute judgment does not just fall on one actor. It's shared by all branches of the state, which all have a very important role to play. And our role at the court is to make sure that our interaction with national court remains a dynamic and continuing one. We will do everything we can to ensure that this is always the case. Thank you for your attention.
Cirlī kundze, paldies.
Madam Cirlī, thank you so much for your presentation. And we are already behind the agenda, the time scheduled for us, but I just want to note that this presentation is very valuable from the practical point of view. Many very valuable tools were mentioned to help us to understand the case law of the European Court of Human Rights and that help in our daily work. But now I give the floor to one of my colleagues who has Anita Kovalevska, who is a senator of the Supreme Court, for her short rejoinder insight into this type of dialogue and the role of a judge. Thank you, Mr. Lavinch. Dear colleagues, I'm very happy about this possibility to be here with you and to address you, and I also feel very honored for this possibility to share my reflections on this very important topic, which was excellently presented by Madam Cirlī. Similarly to Madam Baci previously, I have to say that I have no reasons to object to what was said. I fully subscribe to what was said. And we heard already several times today that the national courts play an important role in the execution of the judgments by a European Court of Human Rights, and it's important to be aware of this role and to play this role on a daily basis. We also heard in Madam Cirlī speaking about about different possibilities for developing dialogue for the national courts with the European Court in Strasbourg, but I believe there are some possibilities still for improving this dialogue. One of the matters which has not been used to full extent is the 16th protocol to the convention mentioned by Madam Cirlī, and the possibility envisaged in it for the national courts to request the European Court to request an advisory opinion. More than half of the member states have not ratified this protocol, and Latvia is among the ones that have not ratified this protocol. Probably this is not only my impression or feeling, but also it's probably shared by other judges. We would really appreciate it very much if we would have this opportunity for developing the dialogue, and if we could use this tool. So I would call upon the officials of Latvia and also of other member states to really consider the possibility of ratifying this protocol. The other point another matter where I see the possibility for developing the dialogue and improving it, it is related to the amount of compensation that the European Court of Human Rights grounds for the identified violation. Why do I find this important? As was said by Madam Ziemele, the Latvian legal system is characterized by openness to international law, and in the work of the courts, we see it manifested in the way that the courts in Latvia try not only to execute judgments in cases against Latvia, but also to implement other judgments by the European Court of Human Rights and judgments against other countries. If we look into our court's judgments, you see references made to very diverse cases. And quite often, as the outcome of this analysis, on the national level, we came to the conclusion that a violation of human rights has been made, and so this means that compensation has to be awarded. The European Court of Human Rights has noted that the person is losing the status of a victim and the possibility of turning to the European Court of Human Rights only if the violation has been recognized, but also that the amount of compensation granted on the national level would not be significantly lower than the ones usually granted by the European Court. And for me, as a national judge, it's sometimes quite difficult because the European Court of Human Rights is not explaining in its judgments how it determines the amount of compensation. And so I have not found accessible materials where explaining these basic principles. And so quite often we find ourselves in a situation where we see an infringement, we see a violation. I don't know, there have been 3 cases against Estonia, the United Kingdom, the Czech Republic. The judgments have been delivered in different periods of time, and it's very hard to understand what should the proper amount of compensation be. So it's quite difficult for us. So I believe it would be really excellent if this dialogue between the national courts and the European Court of Human Rights could continue and could be improved with respect to exactly this matter. Thank you. Dear colleagues, at this point, I would like to thank all the speakers of the first plenary session. I will be honest with you, we are behind the agenda, so that's why I will invite all of you to go for the photo to be taken. After that, we'll have a short coffee break. And I will ask my team to invite you back after 5 or 10 minutes in the coffee break so that we wouldn't really fall too much behind the agenda. I know that the moderator of the next session is ready to proceed, so we are now going to take the official photo. Thank you so much.
Tā, kolēģi, mēs esam nedaudz ārpus grafika.
Dear colleagues, we are slightly behind the agenda. Actually, not slightly, but significantly behind the agenda. So please be seated. Let's not waste any more time. Let's get down to business and to the second plenary session of today's conference. As you probably noticed yesterday, I'm a big purporter of rights to lunch. That's why I'll probably try to discipline you and try to get you on time and the whole proceeding on time. As first, I would like to give the floor to the President of the Supreme Court of the Czech Republic, Piotr Angelasi, who is going to talk about res judicata and reopening of proceedings after ECHR judgments. Please, the floor is yours.
Dear President, good morning, dear ladies, dear colleagues. I will try to be fast. So, first of all, I would like to thank you for inviting me and for organizing this event on the topic, the role of the judiciary in execution of judgments on the European Court of the Human Rights. It is an honor to be able to speak in front of you here and to hear your contribution presenting interesting experience and important insights. The topic of this panel is res judicata. Together with the reopening of proceedings after enforcement of European Court of Human Rights judgment, I would like to present this issue from the perspective of the Czech judge. I have divided my contribution into two main parts. In the first part, I will discuss the general rules governing the enforcement of the European Court of Human Rights judgments in cases where the European Court of Human Rights finds a violation of the Convention. In this part, I would like to mainly present to you the Czech national rules on retrial, which may be of comparative benefits also for your own practice. In the second part, I will demonstrate concrete examples in which Czech courts have dealt with retrial. Thus, I will use specific cases to show which proceedings the dispute involved, how the European Court of Human Rights rules, and in particular, what happened with the dispute at the national level after the European Court of Human Rights judgment was delivered. Without further ado, let's dive straight into the issue without further delay. Principles of enforcement of European Court of Human Rights judgments. General rules governing of the enforcement of European Court of Human Rights judgments. As I have mentioned, I will start with the general rules governing or the enforcement of European Court of Human Rights judgments. It probably does not need long reminding that in Article 46 of the Convention, the contracting states undertook to comply with the final judgment of the European Court of Human Rights in all cases to which they are parties. Enforcement is supervised by the Committee of Ministers. It follows, inter alia, that a judgment in which the European Court of Human Rights finds a violation of the Convention imposes on the respondent state a legal obligation not only to pay the just satisfaction awarded, but also an obligation to adopt general or individual measures. Such measures have as their objective putting to an end the violation found by the European Court of Human Rights and remedying its consequences to the maximum extent possible. In recent years, the European Court of Human Rights has become more and more accustomed to suggesting to states what steps they should take in implementing its judgments in order to comply with all their obligations implicit in the Convention. A classic example is where the European Court of Human Rights concludes that an applicant has been convicted at the national level in criminal proceeding in the course of which his or her right to fair trial was not respected. The European Court of Human Rights does not, in principle, have the power to command the respondent state directly to reopen proceedings, whereas in the past it used to simply reject any request by the applicants on this ground. It has since changed its approach. Indeed, in 2000, the Committee of Ministers adopted a recommendation in which it did not dispute that it was for the competent authorities of the respondent state to determine what measures were most appropriate to restore the status quo ante. It noted, however, that its own experience in exercising its power to supervise the enforcement of judgment indicated that the re-examination of a case or reopening of proceeding might be the most effective or even the only one possible way to restoration to the status quo ante. Again, the most common cases that generally call for the reopening of domestic proceedings are those of criminal conviction that have subsequently proved for some reason not to meet the requirements of the right to fair trial. The European Court of Human Rights has never expressly derived from the Convention the applicant's right to retrial of domestic proceedings which have been found in Strasbourg to violate guaranteed rights and freedom. Thus, the facts there has been not reviewed, either because domestic law does not allow such a procedure at all, because the request for review was rejected for some reason, should not constitute a violation of Convention. Czech practice concerning the enforcement of European Court of Human Rights judgments. If we now turn our attention to retrial itself, it must be said that the possibility of reopening proceedings which have become final is provided for in the legislation of many countries, although they may differ in certain aspects. As I mentioned in my introduction, I will focus the Czech praxis. Simply speaking, in order to access the European Court of Human Rights, all available domestic remedies must be exhausted in accordance with generally recognized rules of international law. In Czech law, an application to the European Court of Human Rights is typically, but not necessarily, preceded by a constitutional complaint, which is decided by the Constitutional Court. In this regard, the reopening of proceedings before the Constitutional Court was introduced into the Czech legal system by an amendment in Constitutional Court Act in 2013. To understand the whole issue, we have to bear in mind that reopening of proceedings is actually a reversal of a final decision if a new fact appears, and that involves a conflict between the legal certainty and the value of justice. In this case, a greater weight is given to the value to the justice. According to the Constitutional Court Act, the condition for filing an application for the reopening of the proceeding are as follows. At A, first, there must be a decision of an international court which the legal system considers to be an international body whose decisions are binding on the Czech Republic under international treaties, forming a part of legal system. This condition is met by the European Court of Human Rights. At B, second, the person entitled to file a motion for the retrial in the person who was a party to the original proceeding before the Constitutional Court. It must also be a person in whose favor the European Court of Human Rights has ruled. Third, the time limit for filing a motion for a retrial before the Constitutional Court shall be 6 months from the date of which the decision of the International Court has become final. On the other hand, the filing of a motion for a retrial is not admissible if the consequences of the violation of human rights or fundamental freedoms no longer persist and have been sufficiently remedied by the satisfaction granted by the International Court or if the remedy has otherwise been achieved. An exception to this rule is made where the public interest in the retrial exceed the interest of the applicants. The parties who the reopened proceeding are, in addition to the person who applied for the retrial, also those who were parties to the original proceeding on the constitutional complaint. Proceedings before Constitutional Court are held without oral hearings. Its purpose is to enable the Constitutional Court to remedy the situation from the original proceedings where it wrongly denied the applicants to the protection of human rights and fundamental freedoms. It is divided into two parts. In the first place, the Constitutional Court assessed the consistency of its original decision with the decision of the International Court, and in the event of a conflict is obliged to annul its decision. The annulment of the decision of Constitutional Court results in the new procedure on the original application, which constitutes the second part of the retrial proceeding. The applicant may not raise the objection which he or she should have properly raised in the filing his or her constitutional complaint. The Constitutional Court is not always obliged to automatically overturn its original decision. The original decision is often maintained in cases where the International Court found the violation of the Convention in the decision of the Constitutional Court itself, not in the decision of the General Courts. Specific cases concerning the Czech Republic and the motion for retrial. After the introduction of the retrial before the Czech Constitutional Court, I would like to focus on specific cases where such a reopening has or has not occurred. I will present the cases in chronological order. I have decided to do so because the first cases where the Constitutional Court allowed the renewal can well demonstrate how the approach of the Constitutional Court has evolved in time. I will subsequently focus on the application of the principles of beneficium cohesionis, talking about cases where the Constitutional Court has or has not granted a retrial, also in relation to a party who was not a complainant before the European Court of Human Rights. I will conclude his series of cases with one Czech recent case, Temple, which introduced important changes to the Czech legal environment. At first, Krčmář and others versus the Czech Republic, case which revealed the absence of the provision of the reopening of proceeding before the Constitutional Court. With that being said, I cannot start with anything other than the first ever case had pointed out a gap in the Czech legal system. It concerns the case of Krčmář and others versus the Czech Republic. In Krčmář, the European Court of Human Rights concluded that the Constitutional Court had violated Article 6 of the Convention by requesting certain documentary evidence, but had not informed the applicant in advance and had not given him the opportunity to offer his or her comments. Subsequently, the applicant who has been successful in the proceeding before the European Court of Human Rights filed an application for a retrial. The Constitutional Court concluded that the retrial was not admissible, even in a situation where the European Court of Human Rights had found a violation of the Convention. It based its reasoning on the fact that the Constitutional Court is a special body whose task is to protect constitutionality. According to the recommendation of the Committee of Ministers of the Council of Europe, a retrial should be admissible where the injured party continues to suffer serious negative consequences caused by the national decision, the remedying of which is not sufficient to provide just satisfaction. The Constitutional Court concluded that in the present case, there were purely procedural defects in the proceeding before the Constitutional Court, which cannot call into question the outcome of the domestic proceedings. In the opinion of Constitutional Court, the Committee's recommendation was merely an appeal to the legislature of a declaratory nature. The fact that the documents have not been disclosed could not lead to call into question the substantive accuracy of the contested decision. Therefore, the Constitutional Court rejected the application for a retrial on the ground that the
Un pamatojums
Court did not allow for a procedure on the motion for a retrial. In the ECHR case, the Czech Constitutional Court was thus confronted for the first time with the problem of how to remedy the violation of the Convention whose victims did not consider the just satisfaction awarded by the European Court of Human Rights to be a sufficient measure. The hearing of the application for a retrial before the Constitutional Court revealed a significant gap in national law. The ECHR case also demonstrated the Constitutional Court's limited experience in applying certain non-substantive provisions of the Convention. However, given the principle of subsidiarity, the Constitutional Court remains to be the main body responsible for the ensuring compliance with the Convention. This gap was remedied by the introduction of the Institute of Retrial in 2013. The second case, Chmelíř versus the Czech Republic and Balšan versus the Czech Republic, historically the first case where the retrial was granted. Following the amendments of the Constitutional Court Act, the Institute of Retrial was historically first used in the cases Chmelíř versus the Czech Republic and Balšan versus the Czech Republic. In the Chmelíř case, the European Court of Human Rights found that the applicant's appeal against the conviction of the Court of First Instance had been decided by the court, which in such circumstances could not be regarded as impartial as required the Article 6 of the Convention. The same provision was also violated in the Balšan case, on the ground that the applicant's conviction rested almost exclusively on the testimony of accused whom the applicants had not had opportunity to question at any stage of the proceeding, since the accused had subsequently exercised his right to remain silent. Before submitting their application to the European Court of Human Rights, the applicants applied to the Constitutional Court, which rejected their compliance as manifestly ill-founded. Following the European Court of Human Rights judgment in favor of the applicants, the Constitutional Court subsequently decided to grant a retrial in both cases. All the conditions under the newly introduced provision of the Constitutional Court Act for such a step were fulfilled in the plenary session of the Constitutional Court, decided on the motion in accordance with the law. The first condition was met because the European Court of Human Rights can be considered an international court whose decisions are binding on the Czech Republic. The second condition was also met because the motion was filed by the person who was a party to the proceeding before the Constitutional Court and in whose favor the International Court ruled. The third condition was also met because the decision of the National Court became final and the motion for retrial was filed within the following 6 months. Therefore, the motion was not inadmissible as the consequences of the violation were still present. The Constitutional Court stated that the redress in the case of the applicants who was criminally convicted in the proceeding before the ordinary courts can only be achieved by a new examination of the original constitutional complaint, taking into account the conclusion reached by the European Court of Human Rights. In the applicant's case, the consequences of any violation of a human right or fundamental freedom remain being present since he is regarded as having committed a criminal offense and is having been sentenced with the final effects to an unconditional prison sentence. After following a retrial, the Constitutional Court re-examined the original constitutional complaint, but this time it had no rely on the legal opinion expressed by the European Court of Human Rights. It had held in the reopened proceeding it was not necessary to re-examine the circumstances of the case, as this would extend an already extraordinary interference with a final decision taken by the body of a sovereign state. The case was referred back to the High Court for a new hearing of the appeal. The third case, Melich and Beck versus the Czech Republic, it is a refusal of the retrial on the basis of the new formulation of petitioner claim. To demonstrate the Constitutional Court cannot rule on a new petition in a renewed proceeding, I would like to point to the Melich and Beck versus the Czech Republic. In this case, the European Court of Human Rights found that the domestic proceeding gave the impression of presumptive conviction of the defendant's guilt. Following the judgment of the European Court of Human Rights and the filing of the motion for retrial, the Constitutional Court in fact granted to retrial. In the reopened proceeding, it refused to rule on the new formulation of the applicant's claim. In this context, the Constitutional Court recalled that the application for retrial was intended to enable the original constitutional complaint to be decided in accordance with the legal opinion of the International Court, not to give rise to a new constitutional complaint. The Constitutional Court, without an oral hearing in the retrial, granted the complaint in full and returned the case to the Court of Appeal for a new hearing. It was for the Court of the Appeal to consider the applicant's appeal in the new proceeding with due regard for Article 6 of the Convention. The Court of Appeal reheard the case and dismissed the applicant's appeal again, but set out in more details ground on which the Court of First Instance had decided correctly. According to the Court of Appeal, the factual findings of the Court of First Instance were complete, correct and supported by the evidence. The applicants challenged the new decision by means of constitutional complaint, arguing that the Court of Appeal had failed to remedy the errors found by the European Court of Human Rights. The Constitutional Court did not uphold this complaint, neither did the European Court of Human Rights, which ruled that by adding explanation to its conclusions. The Court of Appeal had sufficiently addressed most of the criticism found by the previous judgments. The fourth case, Heglas versus Czech Republic, is a refusal of a motion for retrial introduced by applicant's accomplice. In the next case, I would like to focus on the procedure subjectivity. As I mentioned at the beginning, the motion for retrial can be introduced by the applicants who won his or her case in Strasbourg. However, is it not an exception that the motion is introduced by the party to be constitutional proceeding who did not bring the case to Strasbourg? In those situations, the Constitutional Court is deciding wherever to apply the principle beneficium cohesionis or not. Firstly, I will speak about the Heglas case where the Constitutional Court rejected the motion for retrial on the grounds that the complaint was not the one in whose favor the International Court had ruled. Mr. Heglas had been convicted of the offense of robbery on the basis of a review of telephone calls made between him and his accomplice. Following Mr. Heglas' application, the European Court of Human Rights held that the use of the phone records constituted an interference with the applicant's right to respect for private and family life. The motion for retrial was introduced by the accomplice of Mr. Heglas, and the reopened proceeding to the Constitutional Court found that the complainant is applicant's accomplice. Did not have standing to bring the motion for retrial, as he was not himself an applicant in the proceeding before the European Court of Human Rights. Thus, the complainant was a person who was not entitled to reopen the proceeding before the Constitutional Court, and the Constitutional Court had no choice but to reject his motion without a substantive examination for inadmissibility. It should be added that even if Constitutional Court had accepted that the certain beneficium cohesionis would apply in the interpretation of the provision of active standing, such a claim would probably have had no chance to success, since the European Court of Human Rights did not find a violation of the right to a fair trial in a verbal satisfaction was sufficient. The successful applicant himself did not apply to the Constitutional Court. The fifth case, Janir and others versus Czech Republic. Approval of motion for the trial by application for beneficium cohesionis. In Janir and others, the Constitutional Court came to a different conclusion. In the original proceeding, 2 persons were charged with the crime of fraud. After using various legal remedies, the defendants reached the Constitutional Court, which did not uphold their compliance. One of the applicants defended himself against the national decision by lodging an application to the European Court of Human Rights, which was successful. The applicants subsequently applied to the Constitutional Court for a retrial. In the retrial proceeding, the Constitutional Court concluded that the grounds for retrial also benefits the second defendant who had not applied to the European Court of Human Rights. Therefore, based on the principle of beneficium cohesionis, the Constitutional Court annulled the decision in question in relation to the second defendant as well. In the reopened proceeding, the Constitutional Court concluded that there had been no violation of fundamental rights. Now the case Temple versus Czech Republic, the most recent case, unreasonable length of the proceeding. To conclude the list of cases, I will finish with the recent decision in Temple case in which the European Court of Human Rights found the length of the proceeding, which lasted over 10 years, was not reasonable. This delay on the part of the public authorities was caused in particular by the action of the Court of Appeal, which repeatedly annulled the acquittal of the Court of First Instance and sent the case back for a new hearing. On the basis of the provisions of the Code of Criminal Procedure, the Court of Appeal also ordered that the following its annulment of the decision of the Court of First Instance, the case should be heard and decided by another panel of the same court. Later on, even by another first instance court. According to the European Court of Human Rights, the applicant must have felt anxiety and uncertainty about the outcome of the proceeding when he was facing a life sentence. In the European Court of Human Rights view, the second court to which the case was assigned may have been influenced in this approach, as it may consider that one only outcome that the Court of Appeal was willing to accept was a finding of guilt against the applicant. Following the finding of a violation of the applicant's right by the European Court of Human Rights, the proceeding before the Constitutional Court were reopened. The Constitutional Court annulled the decision of the ordinary courts, which had infringed the applicant's fundamental rights to judicial protection and to lawful judge, and remanded the case to appeal stage. Subsequently, the High Court ruled on the appeal, dismissing the appeal brought by the public prosecutor. This gave effect to acquittal of the applicants on the basis of in dubio pro reo. The ruling of the Constitutional Court in Temple retrial established the constitutional condition for the application of the provision of the Code of Criminal Procedure, granting the Court of Appeal the possibility of assigning the case to another panel of the same court or even to another first instance court. The situation which arose in the Temple case will thus not arise again in the future. Such situations rarely occur in practice, and the Constitutional Court had set detailed rules and clear boundaries. Numerical statistics, number of cases against the Czech Republic in 2022. Before concluding, I would like to mention to you some numerical statistics dating back to 2022. In this year, the Committee of Ministers received from the European Court of Human Rights 6 cases against the Czech Republic for supervision of their enforcement, compared to 4 in 2021 and 3 in 2020. On 31st December 2022, the Czech Republic had 7 cases pending enforcement, of which 1 was a lending case classified under enhanced procedure, and 3 were leading cases classified under standard procedure. The only leading case under enhanced procedure has been pending for more than 5 years. The pending caseload includes cases concerning segregation of Roma children in education or unfairness of criminal proceedings. Of the new violation found the court in 2022, some of them concern the payment of compensation for expropriated property of excessive lengths of detention of remand pending extradition. In course 2022, the Committee of Ministers examined the adopted decision in respect of one leading case under enhanced procedure. The committee closed 5 repetitive cases under standard supervision. The authorities submitted 1 minute, please. 1 minute. I'm trying to be fast. The authorities submitted 2 action reports and 1 communication. Finally, conclusion. Overall, there is certainly no doubt that the contracting state have an obligation to implement the judgment of European Court of Human Rights. While the European Court of Human Rights does not have the power to command the response state directly to reopen proceeding, in principle, it is often the only way to comply with the Strasbourg judgment. Until 2013, there was a legal gap in this respect in the Czech legal system. As I have demonstrated in the Kaczmarz case, it was not possible to initiate a retrial at all. With the amendment of the Constitutional Court Act, this approach was changed, and the Constitutional Court could and can decide on the reopening of proceeding before the Constitutional Court. This was the first it was done in the case Chmelíř and Balšán case, where the Constitutional Court held that the original decision was contrary to the opinion of the European Court of Human Rights. It therefore reopened the proceeding and decided the case again. However, the Constitutional Court is still bound by the original text of the constitutional complaint, which cannot be extended by the parties in the renewed proceeding. I have also focused on the application of the principle of beneficium cohesionis, which constitutes an exception to the rule that only applicants who have lodged an application with the European Court of Human Rights are parties to the renewed proceeding. However, this principle does not automatically apply to all parties. Finally, I mentioned the Temple case concerning unreasonable length of the proceeding, which caused a major development in the Czech practice. In the individual measures taken by the Czech Republic is in the wake of this case ensure that the similar scenario would not be repeated in the future. Dear colleagues, I hope that in my contribution I have been able to point out the most interesting aspects that the Czech practice has encountered in the enforcement of European Court of Human Rights decisions. Thank you for your attention, and I am sorry for that I got a bit longer. Thanks.
Paldies.
Thank you for the rather exciting insight into Czech practices. I will refrain from commenting it. I will leave it up to a discussion, because discussion is always much more valuable than just one-sided view. As next, I would like to give the floor to the human rights professor of the University of Liverpool, Konstantin Dzyktyrov. Please, the floor is yours.
Thank you very much. Thank you very much, honorable judges, presidents of the court. I am a great believer in the right to lunch as well, so I'll try to keep my comments as short as possible, but also beyond the right to lunch, there will be a youth choir singing to us in a couple of minutes, and I think that you will much more prefer listening to the choir than to me. I, of course, could have sung my rejoinder, which would make it more memorable, but I would probably spare you from these memories. I would like to thank the organizers for the ability to speak at this forum, and I would also like to thank President Angelossi for sending his speech in advance, so I will make a little bit less fool of myself because I could prepare for this rejoinder. And I have only 5 minutes to say something smart about the very informative presentation by President Angelossi that lasted a little bit over 20 minutes, as we all noticed. And it would be ambitious of me to discuss the interpretation of Czech law, of which I know almost nothing. And which was very eloquently outlined by the president of the apex court of the country. So instead, I will make 3 points, and we didn't plan it with Bashak. It's, my 3 points are different, 2 of which are related to the interpretation of the convention, and 1 on the position of the Czech Republic in terms of execution of the European Convention on Human Rights Judgment. So, first of all, it is really difficult to dispute that there is no explicit right to retrial provided by the Convention. We all know that, and we know Article 6, but as mentioned by President Angelosi, where an individual has been convicted following proceedings in breach of Article 6, the court may indicate that a retrial or reopening of the case, if requested, represents in principle an appropriate way of redressing the violation. And then reopening is not an issue of Article 6, it already falls within the obligation under Article 46 of the European Convention on Human Rights without even explicit reference to Article 6 itself. Having said that, and as everyone pretty much said in the first session, of course the modality of reopening remain with the national authorities. Again, the second point that I wanted to make is in relation to the court's changing approach to repeated violations. We know that in the ancient history of the court would make a pronouncement and would never come back to this issue again, and that's really changed in the meantime, and I would say that the European Court of Human Rights was forced into this by the refusal, first of all, to reconsider flagrant violations or questionable reasoning in the judgment that actually are reacting to the judgment of the European Court of Human Rights. And one of my favorite examples where the court really discussed the reasoning of the National Court is the case of Bachan versus Ukraine, number 2, where the European Court of Human Rights stated that the old Supreme Court of Ukraine recounted that this court had found that the domestic court's decision, the decision of National Court, in the applicant's case had been lawful and well-founded, and that she had been awarded just satisfaction for the violation of the reasonable time guarantee, these being affirmations that are palpably incorrect. So the National Court in that case switched black to white effectively and pretended that this is fine. And this seemed that the European Court of Human Rights had to react to this reasoning. So that, and I don't know that I have 27 seconds left, and I will talk a little bit about the situation in the Czech Republic. And I checked when I was preparing, I checked the execution record of the Czech Republic, and I have to say that this record is extremely boring. And it didn't give me actually much to say, so 5 seconds is actually enough. And I say boring here in the most positive way possible, you know. Execution of the majority of cases is closed. The pending cases are mostly the recent ones from 22 and 23. The only outstanding case is a well-known case of DH versus the Czech Republic, which has nothing to do with res judicata and reopening, so we'll skip that. So it seems that, well, it's an important case, but on a different issue. So it seems that the system of reopening that was described by President Angelosi works quite effectively in practice and is habitually accepted by the Committee of Ministers. Even in the case of Temple that President Angelosi has just mentioned, it was closed by the Committee of Ministers in the April of this year. So thank you very much for your kind attention. I hope it was useful, and I'm looking forward to any further comments and issues on that issue. 1 minute longer than was necessary. Thank you.
Paldies. Nākamā tēma mums ir
Thank you. The next topic is the supervision of national measures of execution of judgments of ECHR and separation of powers. The floor is given to the Judge of Constitutional Court of Kingdom of Belgium, Emmanuel Bribosier. Excelences, godātie viesi, kolēģi, godātie klātesošie, ir liels prieks un liels gods piedalīties
to this conference. As already set out this morning, execution of judgments of the European Court of Human Rights is a crucial step, an aspect in the effectiveness of the system of the protection of rights and freedoms, and more broadly, the respect of the rule of law in Europe. The topic that has been assigned to me relates to the role of the national judge in the supervision of the execution of judgments of the European Court of Human Rights that require the adoption of general measures. When the breach of the ECHR arises from a structural problem, potentially highlighted by the adoption of a pilot judgment, the implementation of the judgment may require the adoption of general measures, particularly of a legislative nature. One of the questions raised by the organizers of the conference is that of coordination and possible tensions between the role of national judge in charge of the execution of the judgments of the European Court of Human Rights on the one hand, and the principle of the separation of powers, which applies in domestic law on the other. It is certainly not by chance that the topic has been entrusted to me as judge of the Belgian Constitutional Court, as there have been two groundbreaking Belgian cases already old, the Marx cases and the Vermeer case, which are key as to direct applicability of European Convention human rights judgments, and as to the role of the judge in this respect. Thus, at the time of the Vermeer versus Belgium judgment rendered in 1991, the European Court of Human Rights abandoned its traditional reserve and the subsidiary nature of its role in the execution of judgments by requiring the Belgian judicial authorities to directly implement the provision of the ECHR as interpreted by the European Court of Human Rights 12 years earlier in the famous Marx judgment. As a quick reminder, the Marx judgment related to discrimination under Belgian law regarding illegitimate children in relation to legitimate children as regards, in particular, inheritance rights. At the time of the Marx judgment, this discrimination was condemned as contrary to the Convention. However, the law change, which required a reform of the Civil Code, was not implemented until 1987, nearly 8 years after the European Court of Human Rights judgment. In the Vermeer case, the Belgian courts had refused to place illegitimate children on an equal footing with legitimate children in inheritances opened prior to the law change. This attitude of certain Belgian judges, justified by the obligation to abide by the law and the separation of power, gave rise to a second condemnation against Belgium at the time of the Vermeer judgment rendered in 1991. The European Court asserts therein that the choice of means left to the state does not allow it to suspend the implementation of the Convention while waiting the wide-ranging legislative reform to be introduced. Provided that the operative part of the judgment is sufficiently clear and precise, the judge is obliged to conform thereto without waiting for legislative reform. Such a position, asserted by the European Court of Human Rights on the ground of the effectiveness of its judgments and more broadly of fundamental rights, was likely at that time to lead to tension with the principle of separation of powers. In this speech, by using Belgium as a case study, I have attempted to map the various roles the national judge, whether constitutional judge or judicial judge, can play in the execution of judgments of the European Court of Human Rights that require adoption of general legislative measures. In each of these instances, I'll consider as a guiding thread the potential tensions between the requirements related to the effectiveness of fundamental rights and those pertaining to the separation of powers. The result of the inquiry shows that presently in Belgium, according to me, this type of tension has largely been overcome, and the role of the judge in enforcing the judgments of the European Court of Human Rights is not seen as conflicting with the principle of separation of powers. So, in Belgium, the Constitutional Court may play a double role linked to the execution of judgments of the European Court of Human Rights. First of all, it can reinforce the finding of a breach of the ECHR by doubling up with a finding of unconstitutionality. Secondly, it may penalize the legislator failure to act as a shortcoming where such failure to act appears to be in contravention with the Convention and the Constitution. First, that since the beginning of the 1990s, the Constitutional Court of Belgium has developed and implements a technique with which it exerts its control over legislative acts that are submitted to it, not only with a view of the constitutional norms, but also with a view to the international and European rules that are binding upon Belgium. The provisions of the ECHR, as interpreted by the European Court of Human Rights, thus play an important role in the indirect rules of reference used by the court in the control of constitutionality. The Constitutional Court of Belgium has a reputation for taking the Convention's rights seriously. It recognizes the interpretative authority, res judicata, of the judgments of the European Court of Human Rights, which it frequently makes use in its case law, and not only the cases against Belgium, but also all the case law of the European Court of Human Rights. With regard to the role of the constitutional judge in connection with the execution of a judgment of the European Court of Human Rights, several scenarios may be envisaged. In a first hypothesis, in parallel to a case brought before the European Court of Human Rights, having led to a finding of a violation of the Convention by Belgium, a preliminary ruling proceeding may be referred to the Constitutional Court, targeting the unconstitutionality deriving from a combination of constitutional and treaty provisions of a legislative rule that is, moreover, at the center of a decision of the European Court of Human Rights. In this hypothesis, it is likely that the Constitutional Court will recognize the unconstitutionality of the legislative rule through the interpretation of the Belgian Constitution in the light of the ECHR. In so doing, the Court confirms and simultaneously reinforces the finding resulting from the judgment of the European Court of Human Rights. In addition to the impact that such a decision in the preliminary ruling proceeding will have on the case before the national judge, such a finding will have the effect of reopening the deadline with a view to lodging an action for annulment of the legislative act found to be unconstitutional. This reinforces the execution of the judgment of the European Court of Human Rights by tightening the screw around the legislator and fast-tracking the removal of the rule violating the ECHR in the internal legal system. In a second hypothesis, the intervention of the Constitutional Court may occur ex post when the legislator has acted to execute a judgment of the European Court of Human Rights condemning Belgium. In this case, an action for annulment may be brought before the Constitutional Court, and this court may be called upon to verify whether the choices made by the legislator to comply with the Constitution, read in conjunction with the provision of the ECHR, as interpreted by the European Court of human rights are the right choices. Thus, cross-references may arise between the case law of the European Court of Human Rights and that of the Constitutional Court, leading to stronger protection of the litigants. For example, in its pilot judgment rendered in WD versus Belgium case, in the matter of a breach of fundamental rights of persons with mental disorders held in prisons, even though they should have been placed in suitable health care institutions, the European Court quotes a judgment of the Constitutional Court, which found a breach of Article 5 of the ECHR due to lack of space available in suitable institutions. Having then received an action for annulment targeting the subsequent legislative reform, the Constitutional Court in turn made substantial use of the case law of the European Court of Human Rights and insisted on the need for the state to abide by the latter. In both hypotheses, this reinforcing role of the constitutional judge enhances the effectiveness of fundamental rights, regardless of their formal source, without creating any tension with the principle of separation of powers. In fact, the role played here by the Constitutional Court falls within the scope of its office and its task of supervising the legislative power. Taking account of the lessons learned from the judgments of the European Court of Human Rights is part of a fruitful dialogue with the European Court, which may also help to avoid future violation by Belgium and have a preventive role. It is a more complex situation when the non-execution of the ECHR judgment results from the failure of the legislator to act in order to tackle a structural problem. The Constitutional Court has not been granted formal jurisdiction to sanction legislator inaction as such, or the shortcoming of the latter in executing a ruling of the European Court of Human Rights. It has nevertheless developed case law in which it sanctions unconstitutionality that derives not from provisions submitted to it in preliminary proceedings, but rather from a legislative gap. In this regard, it should be noted that based explicitly on the Vermeer case of the European Court of Human Rights, the Constitutional Court specified that when a gap is identified in a sufficiently precise and complete manner, it must be filled in by the national judge without waiting a legislative reform. It can thus be seen that the legacy of the Vermeer judgment of the European Court of Human Rights is the basis of the Constitutional Court's case law on self-repairing gap and the determination of the ordinary judge's power when faced with a legal vacuum contrary to fundamental rights. The Constitutional Court thus invited the Court of Cassation to revisit, which is the Supreme Court in Belgium, to revisit its reasoning and agree to fill in itself the gap raised by the constitutional judge, which the Court of Cassation agreed to do in a judgment rendered in the same year. As part of a preliminary ruling proceedings, the Constitutional Court does not itself fill in the legislative gap. Consequently, there is in principle no direct tension with the principle of the separation of powers. Nevertheless, one cannot exclude that such tension may arise due to the obligation of the judicial judge to fill in the self-repairing gap deemed unconstitutional, pending intervention by the legislature. This should lead to the review of the judicial judge's role in the execution of the judgment of the European Court of Human Rights. But due to time constraint, I won't present this part of my paper. You'll have to read it later on, I'm sorry. And I would like to conclude briefly. What does this mapping reveal about the different roles that the constitutional judge may play in the execution of the judgments of the European Court of Human Rights that require the adoption of general legislative measures? In the first type of role, the Constitutional Court reinforces the finding of a violation of the ECHR with a finding of unconstitutionality. In so doing, the Constitutional Court supports the European Court of Human Rights and increases the pressure on the legislature, which is supposed to put an end to the violation of the ECHR. In the second type of role, the Constitutional Court may be expected to sanction the legislator for failure to act in order to execute ECHR judgment. In this case, the Constitutional Court, hearing a preliminary ruling proceeding, may detect an unconstitutionality resulting from a legislative gap. What about the possible tensions between the requirements deriving from effectiveness of fundamental rights on the one hand and those related to the separation of powers on the other? The evolution that has taken place in Belgian legal system tends to show the absence of any real tension between the separation of powers and the different roles that may be played by the constitutional judge in the framework of the execution of ECHR judgments. In reality, this is an interpretation of the principle of separation of powers, which does not involve a strict separation, but rather fosters relationships of interdependency between powers by means of checks and balances. Of course, the balance is precarious and provisional and is by no means immune to a resurgence of these kinds of questions or doctrinal or political stances opposing the role of the judge on the one hand and the role of the legislator, and criticizing judicial activism in the name of popular sovereignty. The fact, nevertheless, remains that this flexible design of the separation of powers, involving faithful cooperation between them, seems to me to be the most suitable fit for ensuring the effectiveness of the protection of fundamental rights and of Belgium's European and international commitments. Thank you very much.
Paldies, un paldies.
Thank you so much. And thank you also for saving some time. And now I give the floor for rejoinder to President of the Constitutional Court of Latvia, Aldis Laviņš. Dear colleagues, thank you. Thank you to Madam Brisbausia for examining this very sensitive topic and for giving, if I may say, some recipes how, for example, within the Belgian legal system, these issues are dealt with. On those occasions when we see, on the one hand, a judgment by the European Court of Human Rights, where a state has committed an infringement due to failure to fulfill its positive obligation. And the question is how the court should act, the national court following this judgment. And then we also have the question, how should other courts of the Council of Europe member states should look at this judgment? And in my rejoinder, I would like to underscore a couple of things. First of all, I really liked the reference or the statements that we should look into the judgment of the European Court where the violation has been found, to see whether those legal remedies have been defined very accurately and clearly, those remedies which could be used to fill this legislative gap. If this is the case, then the national judge, not only in that specific jurisdiction, but also in others, if they encounter cases of similar nature, as a matter of principle, should consider whether he or she himself or herself could not eliminate this gap. And again, this is very important. The emphasis is now on whether it has been defined clearly and accurately in the judgment which these legal remedies are. If this has not been done, or if the judge says the judgment does not clearly show me how I should act, in such a case, and my colleague Kovalevska also mentioned it, it's a deficiency. For example, in Latvia's situation, encountering such a situation, if using the possibilities given to us in protocol number 16, we could turn to the European Court of Human Rights and we could ask for clarification. What exactly is intended by these legal remedies?
And should the same criteria apply also to Latvia as much as Italy in the particular case? So in the first part of our conference, we also had representatives of the executive branch. However, Latvia as a whole should probably think about ways to getting Protocol 16 ratified as soon as possible so that we could avoid cases like these in future. Dear colleagues, every national judge is at the same time a judge that applies the convention and applies the laws of the European Union and national laws. So it's a threefold role that the judge as a judicial professional plays. So it puts quite a lot of strain on the judge deciding that there is a gap in legislation. So when we see regulatory gap and there is the infringement procedure already launched, so we have to act very quickly. So for you to better understand what I mean, I would like to refer to a case study or an example, the criminal procedure law and civil procedure law. In 2002, due to excessive proceedings, Latvia was found in breach of Article 6. In 2005, in criminal procedure law, we already introduced a reference or provided that should the proceedings or trial take excessive time, measures should be taken, whereas it was introduced only in 2010 in practice. So these remedies that could fill the gaps, to my mind, were provided in the case law of the European Court of Human Rights. So judges, in between the amendments to the criminal law, which already provided these measures in 2005, could have been more proactive without waiting for 2010 for the criminal law to be amended. So this is just an example to show you that judge must be very, very sensitive towards those principles, whether stick to the separation of power principle or probably recommend the legislature to make the changes. And when judges step into the field of legislators, we often feel a very, very strong backlash, because what we would, of course, like to avoid, and dialogue is the best way to avoid any tensions between legislature and judiciary branch. So thank you. That's as far as my comments go. Thank you. This concludes the second morning session of our today's conference. And before, despite my attitude towards right to lunch, before lunch we still have a little entertainment, a performance by choir Kamara, and then we'll have lunch. So, as it ends room, the choir will perform here, and lunch will be served on the first floor. Thank you, and we'll see you after lunch. Dear participants of the conference, this year is the year of our National Song and Dance Festival. Once every 4 years, our people are truly united, and our Song and Dance Festival tradition brings tens of thousands of people together on the open-air stage, which has now become also the intangible heritage. And the Youth Choir Kammer, for 3 decades, has been the face of our country. And as young, while we are young, everything is possible. Is there a motto? They have won the Song and Dance Festival main or Grand Prix 7 times. They are 3-time champions of the World Choir Olympics and have also won the European Grand Prix for 3 times. And today you will hear from the choir the most favorite songs of singers at the Song and Dance Festival. Jāzep Svītils, Castle of Light, and Raimonds Tigls, one of our most popular composers, contemporary composers, Morning and Evening Song, and Rise a Sun. And Raimonds Tigls will perform on piano himself as well. The choir will be conducted by the art director of the choir, Juris Cāvols.
Like
Tā, kolēģi, lūdzu ieņemam vietas un sākam.
Dear colleagues, please be seated so that we could start the concluding plenary.
Tā, mēs esam
So we have reached the final stretch. So we have the plenary from 4 o'clock until 4:45. It is my honor to give the floor to the Oslo University Public and International Law Department head, who's going to talk about the future outlook, foreseeable challenges with regard to execution of judgment of the ECHR.
Thanks very much to the local Latvian organizers for this interesting conference. We have had a very good day with useful information and food for thought. I have been asked to present some reflections about the future outlook, foreseeable challenges with regard to the execution of judgments of the European Court of Human Rights. I would like to emphasize the word foreseeable. We have seen several unexpected developments in Europe and may continue to do so. But what we and I can do is to use the current situation and trends and make some qualified predictions about future challenges. The focus of the attention has shifted somewhat over the years. Several of the Interlaken ministerial conferences, including Brighton and Copenhagen, emphasized the court's backlog of pending cases and the backlash against the court, including the debate on the breadth of the margin of appreciation. The focus now the attention is directed towards the challenges of execution of the court's judgments. As the high-level reflection group stated, there are signs of an increasing lack of compliance with the most basic human rights standards of the organizations in member states, which requires serious attention and more resolute action on the part of states within the collective system of the Council of Europe. This is confirmed by the Committee of Ministers' 2022 annual report on supervision. It says, as of the end of 2022, there was a new record number of 2,257 cases, the highest number since 2011, on which information on payment of just satisfaction was not submitted by the respondent states to the Committee of Ministers. In addition, 2022 witnessed an increased delay in the submission by states of action plans and information within the required deadlines. What I will do now is first to try to identify the different challenges facing the system, and then I will go into what are the respective roles, or should be the respective roles, of the court, the Committee of Ministers, and the National Judiciary. So, if we start with the future foreseeable challenges, I have listed a certain category of cases. Of course, they may be debatable, and to some extent they also overlap. But let me start with the interstate and quasi-interstate cases. Interstate cases seemed for a long time to belong to the history, including the old famous cases against Greece and Turkey. However, they have been revived in the wake of the Russian aggression against neighboring states, as well as in some other conflicts between states, such as Armenia versus Azerbaijan and Liechtenstein versus the Czech Republic. A total of 13 interstate cases are pending, covering in total 17 applications. Furthermore, approximately 10,000 individual applications are related to ongoing conflicts. These cases do not only pose special problems, such as fact-finding, but they also require much resources from the court, and they raise issues about the relationship between interstate cases and the individual applications connected to such conflicts, that is, the quasi-interstate cases. The expulsion of Russia from the Council of Europe means that there will be no new Russian cases, but the pending interstate and quasi-interstate cases will continue to require attention. Furthermore, we cannot exclude that there will be more interstate cases in conflict situations between states in the future. Turning now to the domestic structural challenges. The court has addressed structural problems in member states in transition from communism by the use of pilot judgments in repetitive cases, and to some extent by using the Burmich approach concerning follow-up to unsuccessful pilot judgments. The pilot judgments were first used in some Polish cases in 2004 and 2006. Such judgments provide the opportunity to give the respondent state some general guidance on how to resolve the structural problems, and the court will adjourn cases of a similar character until the structural problem is resolved. Pilot judgments have in later years also been used against Italy, Germany, Greece, United Kingdom, and Belgium, and may be required also in the future. The president of the court, Sofra O'Leary, emphasized in her solemn hearing speech this year the need to consolidate democracy and to counter democratic backsliding. The rise of populism and authoritarianism in member states is a recent but serious threat to the values the Convention shall protect. It has been pointed out that authoritarian regimes misappropriate the human rights language to further their goals, but in reality are generally seeking to reverse or undo previous human rights developments and commitments. These developments not only threaten human rights values, but if it undermines the effective protection of human rights by the domestic judiciary, may also result in new floods of cases to the court. The court's protection of key civil and political rights is essential in countering democratic backsliding. The President highlighted specifically 4 judgments handed down in 2022 in relation to the rule of law crisis in Poland. She also emphasized the synergy between the Strasbourg Court and the Court of Justice of the European Union in combating these developments. A new feature of the court's case law is the use of Article 18 in cases of bad faith implementation of the Convention. This is a means to address unwillingness among certain states to implement the Convention in a faithful way. By the end of 2022, there were 13 pending cases concerning 6 states, as opposed to 5 in 2021, where the court had found violations of Article 18 of the Convention. The 6 cases concerned Azerbaijan, Bulgaria, Georgia, Russia, Turkey, and Ukraine. Unfortunately, these challenges may continue and may even increase. Another new feature of the Committee of Ministers' use is the Committee of Ministers' use of the infringement procedure against states in cases of serious and persistent non-implementation. So far, this procedure has only been used in 2 instances, Mammadov versus Azerbaijan and Kavala versus Turkey. The infringement procedure may also be increasingly used in the future. Finally, there are instances or subject areas of resistance against the court's practice that are less dramatic than those in Article 18 bad faith cases. As already mentioned, there was much focus at the Brighton and Copenhagen ministerial meetings on whether the court had gone too far in its effective and dynamic or evolutive interpretation of the convention, and on the possible expansion of the margin of appreciation. There may be less vocal opposition today, but the resistance may remain in certain areas, such as in cases of immigration or LGBTI rights, and the resistance may even increase. Let me then turn to the role of the court. How should the court address these challenges? The Reykjavik Declaration states that the court's current resources are insufficient and unsustainable to adequately deal with the influx of new and pending applications, including interstate applications arising from conflicts, many of which concern complex legal, political, and societal issues, as well as repetitive cases which place a significant burden on the court. The court is faced with new kinds of human rights issues. Most prominent may be artificial intelligence and climate change cases. However, also traditional issues need continued attention. The backlog figures do not seem to decline, rather the opposite. The court's 2022 annual report states that 70,150 cases were pending before the court at the close of 2021, whereas 74,650 cases were pending at the end of 2022. Of the pending cases, 74% concern 5 countries: Turkey, Russia, Ukraine, Romania, and Italy. The court has been given tools to address the influx of cases, implemented extensive effectiveness measures following the Interlaken process. What further measures may be considered? First, the balance between the court's competence to choose its cases and thereby only deal with precedence cases and the most important cases, and, on the other hand, the right of individual applications is a continuous dilemma. In Reykjavik, the member states reaffirmed their strong attachment to the right of individual application to the court as a cornerstone of the system, protecting the rights and freedoms set forth in the Convention. However, the admissibility requirements, the court's procedural mechanisms, and the priority policy has to some extent alleviated the problem. Second, the court could become less active in ensuring the effective and dynamic or evolutive interpretation of the Convention, and it could widen the margin of appreciation and thereby be less intrusive towards member states. There is an academic debate on the extent to which the court has already become more defensive in its supervision. However, the court is there to ensure effective control of the Convention rights. Pilot judgments should be continued, leaving the possibility of the Committee of Ministers, in dialogue with the relevant state, to find constructive solutions to structural problems and thereby limit repetitive cases. The court will also continuously face the dilemma of how specific orders or advice it should provide on how to execute its judgments. On the one hand, the court should respect the right of member states as an aspect of the principle of subsidiarity to choose the appropriate measures. On the other hand, more specificity by the court may be useful both for the relevant state and for the Committee of Ministers in its supervision of execution. We have seen that the court provides such guidance both in pilot judgments and in so-called Article 46 judgments. There are also interesting social science studies on the effectiveness of different kinds of remedies. Article 18 on bad faith implementation should continue to be used, but selectively and as a last resort. It has also been argued that the court should be more specific in its orders in infringement judgments. And finally, member states may want to consider whether the court should be given the possibility to impose sanctions in the form of fines against recalcitrant member states. Lessons may maybe be learned from the experience of the Court of Justice of the European Union on the use of such fines. However, it is important that the court should not be too much focused on backlog figures. There are limits to what the court can do if states do not implement its judgments. The court's credibility rests ultimately upon the quality of its judgments. Therefore, the efficiency of the court should never be allowed to trump the quality of its decisions. Then to the Committee of Ministers. The member states in Reykjavik recalled that the large majority of judgments are fully implemented, but they were concerned also by the lack of engagement, delays, and failings in implementing certain judgments, undermining the authority of the court and seriously threatening the effectiveness of the Convention. In the Committee of Ministers 2022 Supervision Report, the committee concluded that there has been an increase in the total number of judgments currently pending full execution, 6,081 compared to 5,533 in December 2021. It stated that the main challenges of the committee are twofold. On the one hand, the political and legal complexity and sensitivity of the issues examined by the Committee of Ministers continue to increase. On the other hand, this challenging situation is compounded by the high number of long-standing, systemic or complex problems which have not been resolved by the states concerned, and which the committee therefore continued to examine in 2022. The Committee of Ministers faces the following challenges. First, interstate and quasi-interstate cases will remain problematic, not only for the court. The execution of judgments against unwilling states, and not only Russia, may raise formidable problems. A pragmatic approach to the domestic structural problems should be supported. The high-level reform group stated that a change in paradigm may be needed. It said, the judgment of the court should not be seen as the end of a process leading to blaming a state party, but rather as an opportunity for improvement with the assistance of the Council of Europe based on an accurate needs assessment performed by the court and the monitoring bodies. This should not undermine the final and binding nature of the judgments of the court or take away the obligation of all member states to abide by its judgments. I believe that the latter part merits emphasis. Judgments are legally binding and must be respected. However, this does not prevent consultations and assistance concerning how the judgments should be best implemented. The Reykjavik Declaration follows up the reform group's proposal. It says, we will continue supporting the court's efficient and timely response to pending applications and redouble our efforts for the full, effective, and rapid execution of judgments, including through developing a more cooperative, inclusive, and political approach based on dialogue. It is interesting to note on the positive side that in the Committee of Ministers 2022 Supervision Report, the committee recognized the achievements of the Ukrainian authorities who, throughout the 2022, continued to work on the supervision of the execution of the judgment against Ukraine in extremely difficult circumstances, demonstrating commitment to the convention system through the submission of action plans and reports in many pending cases. However, execution may be more difficult where the Committee of Ministers meets political challenges. The high-level reform group stated, irrespective of the nature of the obstacles and the reasons for the delays in execution, a more political approach is necessary, notably for cases where enforcement faces a lack of political will. In the Reykjavik Declaration, the member states affirm the need for a cooperative and inclusive approach based on dialogue in the supervision process to assist states in the execution of the court's judgments. And they call on the Committee of Ministers to continue their work enhancing the tools available in the supervision of the execution of judgments with clear and predictable gradual steps in the event of non-execution or persistent refusal to execute the final judgments of the court in an appropriate and flexible way that takes into account the specificities of each case. Such political challenges may be more important as we experience more democratic and rule of law backsliding in Europe. These developments can provide the basis for more use of the infringement procedure, but it also raises questions about how far the member states are willing to go in upholding the convention rights and to increase the scarce resources of the execution department. Finally, turning to the role of the national judiciary, and I will be very short here. Domestic courts shall apply domestic constitutions and legislations. Dilemmas can arise, as we have heard, if there are tensions between domestic law and the European Convention. This conference has focused on issues related to protection of constitutional identity and the res judicata status of domestic judgments. National courts should act as transnational mediators between the national and the international legal system in balancing the respective roles of the European Court of Human Rights and the national legislature and national courts. However, it must be emphasized that the national judiciary has an essential role in preventing democratic backsliding by protecting civil and political rights and the rule of law. To conclude, this is challenging times for the European human rights system. The current attacks will likely continue and may even worsen. Meeting these challenges requires determination and new responses. But it has been said in the recent textbook on the European Convention that it is precisely in unprecedented times of crisis that Europe has most need for an international court of human rights. And I would add the equal need for a strong system for execution of the court's judgments. Thank you.
Paldies profesoram Ulsteinam.
Thank you, Professor. Now we have some time for discussion, so you can either ask your question, raise your hand, and you will be given a mic. The mic will come to you. You will be able to ask the question or make the comments. I, unfortunately, because of the lights, cannot see you, but hopefully our people with the mic will spot you and will bring the mic to you. So please raise your hand if you wish to speak. So there are no questions, it seems. So since we have no questions, which is actually good because Professor has to leave. Oh, well, my apologies, we do have a question. My apologies. I was thinking, should I ask in Latvian or in English? I should rather ask it in English, since Professor spoke in English, it will be easier for him.
To ask, if you mentioned you started with a lack of resources of the court and actually growing number of more complex cases to court, and there is also discussion that there are limits what the court can do using the methods it has, pilot judgments, prioritization of cases. How do you see, if it's a pretty open question, if do we need some more really fundamental discussion about reforms in a sense that, and also role of the court and the role of individual applications, or should with existing resources you would still see that the court can do its job in a qualitative way? Thank you.
Yeah, this is a very good question. I think that, as I said, there has been very much a focus on the effectiveness of the court and the backlog during the interlochen process, and as I also said, the court has taken very many measures to increase the effectiveness. I'm not sure, but maybe the court could say more about this, to what extent it is really possible to increase the effectiveness to a great extent. As was mentioned, there is a need for more resources to the court, which was acknowledged in the Reykjavik Declaration. But I would think that there could be more issues about to what extent the court should be more specific in its directions to the member states on how to implement judgment. That could be both in the operative part of the judgment, Article 46 judgments, or in the reasoning by the court. There is also the question about the court's role in infringement proceedings, whether it should be given more or be given the possibility of sanctions in these proceedings. So there are issues that are partly in the hands of the court and partly in the hands of the member states. And then I think that there are certain ways that are politically very difficult, such as restricting the access or restricting the possibility of individual applications. That has been discussed for the last 20 years without any change in the current position.
Paldies. Jautājums profesoram
Question to Professor Jekterov. From Professor Jekterov.
Quick question on 464 infringement proceedings, like the failure in Kavala case to implement it. What does it tell? You said that 464 should be increased in numbers, but maybe Kavala shows that it might not be a good idea to increase the number of infringement proceedings. They might just not work, and this is another ping pong between the court and the Committee of Ministers in implementation of this judgment. Thank you.
Paldies. Just one small qualification. I found a bit weak in the slide in particular that courts are only moderators of ECHR obligations. I think we heard both in the plenary this morning examples from Judge Priborozia, but also in our panel in particular. I think there are cases when a violation is ongoing, when the Strasbourg court gives the judgment, is still ongoing. I think then courts are more than moderators. They have a duty to put an end to such ongoing violations, be it ongoing custody, like in Kavala, be it access to children, for example, custody, in this kind of situations where the obligation of cessation applies. I think this is an obligation which is so concrete and so precise that national courts can and should act, not only as moderators, but as enforcers of ECHR judgments.
Paldies.
Should I?
Any reply?
Okay, yeah, sure. To what extent the infringement procedure works, I think it depends on the country, it depends on the political situation, etc. So it's a very context determined whether it works or not. But that raises also the question about whether there should be sanctions. And again, one can ask whether sanctions would make a difference. I think it's worthwhile discussing. And as I said, the EU court has the possibility of sanctions, but they don't necessarily work. But I think it's worth discussing. Regarding continuous violations, I totally agree that then there is an obligation upon the domestic courts and the domestic authorities to just stop the violation. But sometimes it is a question about what is the obligation of the state, depending on how specific the court is in its operative parts of the judgment.
Paldies. Vai vēl ir jautājumi?
Thank you. Do we have any other questions? So thank you, Professor, for your answers. You can now leave to the airport.
No,
Yes.
sorry.
Thank you very much. Yeah.
Dear participants at the conference, our conference is slowly drawing to a close. We have only a couple of items on our agenda, such as the concluding remarks and also the concluding remarks from the organisers. I would like to now give the floor to the Latvian judge of the European Court of Human Rights, Martin Schmitz, who will provide the concluding remarks. He's been very carefully or closely following all the proceedings of today's conference and will share with us the main conclusions or the findings or takeaways from this conference. According to him, Martin, please, the floor is yours. Thank you. It is indeed my honour and pleasure to do probably the unthinkable, to squeeze within 5 minutes everything that we discussed today with regard to these rather complex issues. Given that we are at an international conference, I would like to address you in English, however.
Everyone agrees that execution of judgments is a crucial element of the rule of law. When court judgments and decisions are not executed, it is the integrity and functioning of the relevant legal system, whether national or European, which is undermined. Before we dive into the problem areas, however, it is worth to remind ourselves that the convention mechanism indeed is the most efficient mechanism in the world, comprising a ruling by an international court, followed by supervision of its implementation by a political body, the Committee of Ministers. With respect to the execution of judgments, there have been named 4 types of obstacles. First, political opposition in member states, financial or other practical difficulties, absence of an effective execution mechanism on domestic level, and constitutional identity as an opposition to execution of a judgment. Each of these elements have, of course, bring their difficulties, and I think we can discuss them at length. The conference concentrated on the last one, constitutional identity as an obstacle. But first of all, is it only an obstacle? It was said that the compliance with the rulings of the European Court of Human Rights and hence their execution is part of the constitutional identity of the European states, making up the Council of Europe. And it is difficult to disagree with that. In the discussion on the constitutional identities, much depends how we understand them and, importantly, how the relevant actors, domestic judges and international judges, understand them, because, as a rule, it is rather a different weight attributed to the various elements making up the circumstances of the case in the balancing exercise carried out by judges, rather than straightforward clash of values leading to the opposite outcomes on the domestic and European levels. If it is the latter case, clash of values, then we have a serious problem. And there are examples in the work of the European Court of Human Rights, such as total lack of protection of homosexual persons, like in Russia, or the interference of the legislative and judicial powers, independence of judiciary, as in Poland. However, it was also pointed out that there is a need for a dialogue, which importantly is based on true dialogue based on good faith, which to my mind means for the European Court of Human Rights and also for the Court of Justice of European Union to delve into the required level of detail and depth to fully see the context which needs to be taken into account when carrying out its own assessment, and for the domestic courts, equally deep comprehension of the human rights standard and a very careful balancing of the values at stake. And I think that there are a number of positive judicial dialogues from both courts, and I think that Latvian audience will know well the recent case in Savickis versus Latvia, which I think is such an example. There is, of course, another avenue, infringement procedure under Article 46. And as we know, there have been only 2 cases, both involving Article 18, by the way, which means that the restrictions of human rights were applied for ulterior purpose, not for the legal one, as it should be. Is this a way further to enhance the execution of the judgments, or is it a way to political deadlock? That's a question that we can pose. During the conference, when we discussed res judicata and opening of proceedings on domestic level, and as well as in the introductory part, a question of the domestic judge as an intermediary was highlighted, an intermediary between the Strasbourg court and the national legislature. Without infringing on the competences of the legislature, there often is a space for judicial interpretation of legal provisions, and I think that this certainly is a way forward, looking from a perspective of efficient implementation of the Convention standards. Erga omnes effect of the rulings of the European Court of Human Rights is another unexploited possibility. Ine Tazemele pointed to an interesting idea that if on domestic level, the attention would be institutionally paid to the case law of the European Court of Human Rights against other countries, many forthcoming applications to the European Court of Human Rights from the particular country could be simply prevented. But this is not the usual practice so far. As to the future of the court, as we were soberly reminded, there is 75,000 applications, of which 80% approximately are repetitive cases. How this situation goes together with the necessity to delve, to go into the dialogue when there is a serious questions on the application of the Convention standards, and there is a need for a judicial dialogue which requires time, essentially. Certainly doesn't go together. And the current situation poses a valid question, actually. What is the future of the court if it is placed between the two stones which are, not to say potentially could smash the court at some point in time, but at least hanging above the heads of everyone working in Strasbourg. I think that some new and thorough discussion is needed, actually, how we want to see the court in the future, if we want it to be attentive and understanding and going into the depth of domestic situations, and at the same time producing individual justice in all the cases which are pending before them. So on this note, I will end. Thank you very much.
Paldies, Eiropas.
Thank you, Judge of the European Court of Human Rights, Martin Schmitz, for providing summary of the conference. It always has seemed to me to be a very challenging task to prepare such a summary in high quality of the conference. Thank you, Martin. You succeeded. And now I give the floor for final words, closing words to President of the Supreme Court, Mr. Igor Strupiš. Well, we've had words of conclusion, and now really the closing of the closing. I would like to share my conclusions and my reflections, but I will do that very briefly. I have two conclusions. The first one is, It's very pleasant to see so many friendly faces, well-known faces, people. And the second conclusion is we should organize such events that would last a week. But now my reflections. Well, coming back to what I said in my introductory speech, I said that we live in different circumstances. We, in Latvia, we live side by side with an aggressive neighbor, and this demands a different approach. And when we had that breakout session, my colleague Jautrīte Briede said about Ždanoka case, like 7 against 8, really through the eye of the needle, the state of Latvia won the case. Of course, that's a good thing on the one hand, but on the other hand, it's a bit frightening how close we were, especially in these circumstances. And here, when we speak about the constitutional identity, and this example was mentioned in the context of constitutional identity. Constitutional identity is a very extensive concept. And actually, that creates some of the problems. It's not only extensive, but also sufficiently abstract and neutral, and does not reflect the actual situation. It comprises different aspects which perhaps people who have not encountered these problems do not create any concern for people. For example, language use. Well, you use whatever language you want and so on. However, if you go to the other end on the spectrum of seriousness, for example, threats to the existence of the nation, this is also part of constitutional identity. And here, try to replace, in the discussion, the concept constitutional identity with the concept threats to the existence of nation. All situations differ, and each situation, of course, has to be assessed separately. The other phrase which caught my attention, that was said by our colleague Inete Ziemele. She said that judges are not always right. And that's true. So what to do with respect to this? How to decrease those consequences which can be caused both by the fact that the judge is not right, or perhaps we do not really understand the context in a specific case. I believe that here we should speak about dialectics. Well, European dialectics in European human rights is, well, we live in different circumstances, different people, different states of Europe, and different political circumstances, and yet we are united by common principles. And here we see the first driving force of the dialectics, the conflict between common principles and different circumstances, and this should be kept in mind. Secondly, dialectics of development in law. This dialectics, actually, this is a conflict, and this is a driving force for the development of law. When I was a student at the university, I quite liked the concept of Robert Jering, a fight for rights. This concept that rights and law develops through struggle, through fighting for them. It seemed quite interesting at the time, but you cannot really understand it before you have seen how the law functions in reality. When you really see how law develops, and how the parties litigate also, and how law develops. And we see the same relationship between the European courts and national courts. This is also a driving force for development of law. A constructive conflict is nothing terrible. This destructive conflict is terrible. We should not be afraid of disputes regarding some questions. Because, well, there's no recipe for preventing conflicts from becoming destructive, how to minimize the possibilities for judges to make mistakes. This recipe is theoretically simple but quite difficult to implement. And the recipe is dialogue, listening, open mind, and empathy. And this is the way we can talk, we can discuss. This is the way how we can approximate understanding, because we need similar understanding, both for the development of national law and for the development of human rights, especially regarding those very relevant issues that we encounter now due to war in Ukraine, which has also been mentioned as being, well, very important in terms of the rights of the child. Well, dialogue and listening, this really does not create problems for us. We keep talking, we have this conversation, we develop the dialogue. Open mind, keeping an open mind is a bit more complicated concept, just like empathy, because it's quite hard to understand what you have not experienced yourself. But this means that just we need to talk longer and we just need to listen more carefully to each other. And this conference very organically fits into this recipe. This is what we are doing. We are talking to each other, we are trying to understand each other. And indeed, I'm very happy to understand that both the European Court of Human Rights and the Court of Justice of the European Union are respecting more and more those national particularities. That was more difficult to achieve a decade or 2 decades ago, but now this is already functioning at a higher level. So we see results of our work, our conversations have results. And this is our common achievement. Thank you for participation in the conference. Thank you for the conversation, for spending your time, for being with us together and participating in this dialogue together with us. Thank you. And now, closing of the conference, concluding words, Aldis Laviņš, President of the Constitutional Court. Dear colleagues, at the very, very closing of the conference, from the bottom of my heart, on behalf of the team of the Constitutional Court, I would like to thank each and every of you who participated in the discussions. I would like to thank keynote speakers, participants of discussions, moderators, all of you for your contribution, really to find the high-quality conclusions and findings during the conference, and that will help us to reinforce the rule of law. And as already habitual with the Constitutional Court, all these findings will be collected in published papers, and we will forward to you this publication. And I would like to thank also the Latvian National Library for hosting the conference. We've spent the time in this castle of life, which the people of Latvia are proud of. And this hall has wonderful acoustics, and so it allowed us to enjoy a wonderful performance by the choir Kamar. And some colleagues told me that the performance was very moving, so that people were crying or were close to tears. So I would like to thank our artists and the choir for this very magic performance. I would like also to thank my team, inexhaustible team of the Constitutional Court, and also colleagues from the Supreme Court for organizing this conference. Many participants were complimenting us on organizing this conference. And the teams of both courts were acting throughout the year as one team, and I'm not exaggerating now. And for the last couple of days, they were together for days and nights. I would definitely want to thank, now speaking about my team, I would like to thank legal department and the head of the legal department, Mr. Kristaps Tamuš, for his contribution in preparing the content of this conference. I would also like to thank the Chancery of the Constitutional Court they were able to deal with the technical side of the conference. Thank you. And my personal thanks go to Einar Stintman, is Executive Director of the court, who was really supervising all processes related to conference. And our interpreters, apparently the interpreters are somewhere high up waving us, so thank you for interpretation. And all speeches, all presentations were interpreted, and this really helped us to understand each other better. My special thanks go to Ksenia Vitola, who is the head of our Department of Public Relations and Protocol, who tried to place the content of the conference on different platforms so that people in Latvia, the audience in Latvia, not only in Latvia, would be informed about the conference. And finally, I would also like to thank personally the head of administration of the Constitutional Court, Marija Laizāne Jurkāne. She is in the back row. Thank you. All communication supervision was her task, and I'm very happy that she did such excellent work. Communication with so many participants of the conference, it's not that easy. Those many hours, I really, as the president, I have to appreciate this loyalty. And also I would like to thank Marika and also my advisor, Andrejs Stupins. He has always been side by side whenever support was needed during the conference. Thank you. And I would now say also all these people deserve a round of applause, all these people who were involved in organizing the conference. Just like President of the Supreme Court shared some reflections, I will also share very briefly some reflections on the content of the conference. If we want to reinforce the rule of law in the European cultural space, then we have to say to ourselves, am I truly a judge who applies the European Convention of for the Protection of Human Rights? Am I a judge who applies the EU law? Am I a judge who applies the national law? And if we answer in affirmative to both these three questions, and if we pay attention to these questions in our work, then the standard of the rule of law would keep increasing. And another point, indeed, currently we are living in very turbulent times in Europe. That's the reality. And Europe needs to be united, because when we are united, we are powerful, and we can deal with an aggressor. And in this respect, I really found the song performed by the choir, the lyrics also seemed to me very moving. It's always quite difficult to interpret poetry. But and at this point, I would like to say, rise, sun, penetrate the darkness and unite all Europeans. Well, see you at other events, and I wish you to enjoy this warm autumn evening in Riga tonight and also tomorrow.